instruction, my lord. Lordship grant some time, we will implement the order.
No, but he is going to retire.
But
He is not going to retire. He
Well.
is going to attain the age of superintendent.
my lord, grant some time, we will do it, implement.
30 तारीख
Lordship.
start करছো 30 तारीख बाद 30th last
All right, Friday I'll take up.
My lord.
Friday first.
I may be permitted to mention, my lord.
This matter was listed, directed to be disposed of today, my lord. But it has been listed today before your lordships. And I filed an IE also.
Disposed of today.
No, did not.
Today it is wrongly listed.
My lord.
They notify them.
Tomorrow, my lord, only I pray, my lord.
It will be notified today. It has been wrongly listed. It will be notified today before DB2. All right.
Pardon, my lord. May I permit to mention, my lord?
Mr. Senior Counsel is want to make a mention.
No, of the list, not out of list.
All right, please take a chair in the middle.
May. This is matter related to examination of BSc nursing course. In similar matter is on the list item serial number 9, my lord. My matter may be taken up today, my lord. Otherwise, the read petition will become infructuous, my lord.
When did you file your writ petition?
I have filed read petition 11th July,
11 July.
my lord.
Defect free.
Defect free. I have got the
Alright.
number, my lord.
And on 11th, you file your writ petition and it is going to become infructuous today.
Sir, and dude.
So you could have filed earlier if that was the position. And then you could have mentioned earlier. When you filed the writ petition on 11/7, then you could have mentioned yesterday. So why was I absent? Sorry, I was absent on Monday, but
Will it
let's
become
see what happens at
infructuous today or end of this month?
Not today, because the examination will be started from tomorrow. Similar identical matter is on the board. Item number 9, my lord. Item 9.
Students of SC/ST who have got below 50%.
Below 50%. Item number 9.
your case will be guided by whatever order we pass. All right.
That's why I have kindly taken up. My lord, kindly.
Sorry.
I may be pardoned to mention, my lord, this is a 2002 matter of regularization of an employee. It was challenged before Orissa Administrative Tribunal, which was dismissed. Again, it was challenged into.
What do you want? You are
It
speaking
should
on
be
merits.
taken up into the list.
Is this DB matter?
My lord,
Is it a DB matter?
my lord.
You are challenging the order of the tribunal.
No, my lord. It
Single
was
judge.
dismissed. Honorable Apex Court had restored the matter and remanded.
Where is the order of the Supreme Court? Give the order of the Supreme Court. Then.
My lords, may I be pardoned. One CMAPL, my lords, a bench has been constituted by a lordship along with my lord Justice C.R. Das. So, my lord, on any convenient date,
It will be listed. Don't make a mention. Let me try whether without mentioning such matters are being
may I submit the
listed or
memo-
not.
May I submit the memo?
The
No,
deputy
not
registrar. The deputy registrar.
Do you give that to the
Deputy
Deputy Registrar Judicial?
My lord,
I'm trying.
my
May I be permitted to mention, my lords?
Yes.
Am I appearing through VC, my lords?
Yes.
My lords, it is with respect to bail application number 5616 of 2024.
Right.
It is listed before His Lordship Honorable Justice A.K. Mahapatra.
Right.
It was last listed on 26th of June 2024. Sorry,
Yes.
27th of June 2024. On which date His Lordship directed it to be listed to list the matter on first week of July, my lord.
Right.
Though it was directed specifically, but it was not listed. It was left out from the list. I have submitted multiple mentioning memos, my lords. Multiple mentioning memos. But it has not been listed till date, my lords.
Make a mention before His Lordship again.
I'm submitting every single day, my lords. Every single day. Even I tried today itself.
That
Before
will not
approaching
be
your
proper.
lordship.
That will not be proper for me. Let me see.
My lords.
Let me see.
My lords. Much obliged, my lords.
My lord, but tender matter in which work order was issued in favor of me, I have deposited bank guarantee, but they are again advertised to re-tender that.
They must have cancelled.
My lord?
Earlier tender.
My lord?
They must have cancelled the.
No, my lord, they have not issued any cancellation order.
Then you should be happy.
My lord,
You have the work order, you may start doing work.
but they are not providing the area over which I will construct the building.
You must be knowing where is the area.
My lord, I have filed
Just
this
get
matter.
the foundation stone laid and start work. Because you have the work order.
But they are not providing me the area over which I will construct that building.
That must have been there in the tender notice itself.
No, they have not mentioned the area.
Alright, we will see later. Not very early.
Next week, if it may be released.
Give us.
My lord, I am the respondent in appearing in person of writ appeal 510 by 2024. My lord, my case was reserved on 10th of April 2024 and 4 weeks of time was given. On 13th or 14th of
Where? This bench?
this bench.
It will be delivered.
Sir, one request, sir. Sir, I have already annexed the written arguments along with the judgments of the Supreme Court under what conditions revaluation can be conducted. Means wrong, if wrong answer key will be wrong or
Give you.
marks not awarded.
Right. We will try to understand.
Millets, may I mention a tender matter, Millets? Your lordships had issued notice in this matter. I had challenged the selection as in the technical evaluation of opposite party number 2 that was opened despite he not having the prerequisite criteria. Notice was issued. I had communicated this to the opposite parties. In the meanwhile, work order has been issued. I have filed an IA. If your lordships can take up that matter. And another, Millets, the second mentioning, your lordships had heard the matter. But judgment in that matter has not been reserved. Your lordship would remember that's that NEET students matter. He had the qualification to actually get a government college seat, but he could not get it because of a technical glitch. Your lordships had heard the matter. I had submitted the written note of submission.
I may pardon to make a mention from the list item number 2. And the Advocate General will address that matter.
You will appear.
I will appear, but today only in the morning I got the brief. I have not completely gone through it. If you can call any day next week.
In fact, I mistook when you said morning. I heard money.
Money is gone. Money is gone.
Evening
always. Now I have to Millard, go with the begging bowl and my senior is there to take care of.
Yes. Yes. When do you want?
33 more. Next week, any day convenient to your lordship.
Another matter also 33.
33. 2 and 30.
Ask someone to be here.
Next week, any day, your lordship is coming.
We will fix.
Oh, no issue.
Today
only Millard dies.
Item position may maintain, ma'am. The position, my lord.
Battery.
Last.
Retaining its position. See, Mr. Acharya, you ask someone to be here. In such cases where you have difficulty and you want adjournment because of the new development, we will be adjourning the matter next week, retaining the position of those cases. All right.
I'm so grateful. I'm so.
Sure.
Item number 6 in the list, writ appeal. It has come on my mention, but I have found it, other side has entered a caveat. Can it be taken
Item
up?
6.
Can it be taken up day after tomorrow? Today I will serve the petition on him.
All right.
I pray only day after tomorrow.
My lord, I am for the respondent.
Monday, sir. It will come on Monday because Friday there is special.
My lord, I am for the respondent in this case.
He is entering. I have said I am serving a copy.
You'll get a copy.
My lord, let it come 7 days after I will file my reply. I will take instruction. They have not sought the copy on me.
Writ appeal is there for the further reply.
See, you will be, in fact, you may not be required. We don't know. So let us hear that first. All right.
Yes.
Mr. Mahanti, you have a copy today.
I will get, will give in course of the day.
Yes.
Item number 1.
Mr. Mishra, we are not interfering with the order.
Okay, can I just indicate one thing, Merit? Because your lordship said both had no qualification at the relevant
No,
time.
both have no qualification. That is we would have gone into that aspect.
Right.
But the learned single judge has rightly finally ordered that post shall be filled up in accordance with law.
Right.
So it is not that post will be filled up by him, by her, by his client.
The only thing I would like to bring your lordship notice. Sir, actually, I was feeling about the person who actually got selected and joined in 2001. 2000, your lordship knows the salary must be 5,000 or 10,000, not more than that. She's a married lady, and she continued from 2001 to till today. She's continuing, and she has no fault. She produced all the documents for the authority, whatever she had at the time of walk-in interview. The government has filed a counter at the relevant time, since it was its beginning. It started the organization itself in the center where actually it was opened at the aid of the central government. They had no rules or regulation for appointment.
See, you were appointed as what?
Sir, actually, it's a vocational counselor.
All right.
Vocational counselor only to.
Whether it was contractual or regular?
It was contractual.
It was contractual.
Yes.
So on contractual, based on a qualification which was not sufficient to fulfill that, you have continued for all these years.
Right.
You should be satisfied. Now the posts have been created. That post has been created.
Right.
The post will have to be advertised. Then therefore, the learned single judge has rightly observed that the process of selection.
Yes, my only request will be, Malad, keeping in view of the scenario of the matter, or let them advertise, Malad. I am continuing there since 2012.
No, that will not.
No, this is only counseling. This is nothing
no question
else.
Of counseling. No question of counseling. It's question of the fairness in the process of selection. It's question of the basic qualification. These are main questions.
But there are instances, appreciation.
Just I am giving you an example.
May I just
we are giving you a very simple example. You have been in practice for so many years. All right. And you must have resolved so many disputes amicably, which is resolved through a process of mediation. Just an example. All right. And a person who acquires that training within 40 years, there is a 40 years training. So he has the authority under the law to undertake a process of mediation, which you cannot.
Right.
All right. Despite your all experience, senior counsel, advocate general, even C cannot, I can, because I have that qualification. So 40 hours. 40 hours. So it's a question of qualification. All right. And fairness in the process.
Yes. One word, sir, can I add, Manoj? The government has given a counter, paragraph 13, that exactly I wanted to show your lordship. It is further submitted that meanwhile, Government Health and Family Welfare Department communicated by letter dated 1/3/2023 that Government of Orissa Health and Family Welfare Department are pleased to resolve to merge that RSIC and SC Medical College. A special governing body was held on 10/8/2022 on the chairmanship of Secretary Health and Family Welfare Department. Government body was dissolved and institution is redesignated as Physical Medical Rehabilitation Center for better management and utilization service. New posts have been sanctioned and suitable mechanism will be there. If they advertise, I should be given opportunity to apply.
Surely, if you have the qualification, you can surely apply.
Dispose of with that observation.
All right, anyone. All of you, both. He can also.
The development that has taken place. Now they have rules and business, Malad. Now they have the regulation under which we will be guided.
Right.
So let them do that in accordance with law so that.
Right.
even after filing of the counter affidavit, pursuant to the direction of this honorable court, an affidavit was filed on 10/4, where the government has explained that the post after creation of the regular post, the posts have been filled up purely on the basis of seniority, keeping in view the contractual appointments made prior to creation of post. So they have not resorted to the recruitment process. That is what is in record.
Once the posts were created, you were required to advertise. You could have given preference. You could have given, additional this thing for the experience. But not that you can fill up the post is created, someone is working. This is not the, therefore.
You also indicate those things of what I productive.
I'll do.
Grateful.
Item number 2.
Item number 2, my lord, sir. That matter
Date.
next week.
This particular.
Next week,
First.
when? First. Retaining solution.
Item number 3.
My lord, I am filing affidavit today. This is regarding that issuance of
Sir, Nursing College,
nursing.
but today just now they are giving an affidavit. You know, directed to give it earlier.
So what is there? So you want to consider
My lord,
You take
a council
I-
affidavit has been filed on behalf of the,
just now they have served.
on behalf of MET. Today itself, stop. Council and senior counsel appearing on behalf of the petitioner states that he is required to consider this counter affidavit. List this matter on tomorrow.
I'm sorry that I received just now.
No, it's all right.
Okay. Okay.
Case admission item number 4.
Item number 4, you will also yesterday have filed an affidavit regarding that similar cases also they have done it.
He wanted to go through.
You want to go through. He is requesting me to take 2 days time to get the instructions.
He is requesting you.
No, I was informing him that I will request the honorable court. He has requested.
All right.
Because why I said so, my lord, kindly see the similar order.
All right. So when do we list?
2 days time.
As jointly requested, list this matter on Monday.
Oblige.
Item number 5.
Yesterday the matter was
Yes.
I had indicated lordship pursuant to lordship's query that I have taken that specific grounds that all other judgments my lord covering the field has been ignored by the honorable single judge on the ground that your case order was passed.
Agree.
This is on the first one. That's him.
Tarsans. Subsequent in all other cases, it was held that Tarsensing is not applicable.
No, he didn't have it. So you did not challenge, then what can be done?
Not challenge, that's a fact. I can't deny that, my lord. But subsequent applications have been filed, my lord, directions have been issued. At least they could have, government could have considered on that basis, my lord. And the honorable single judge, my lord, could have considered that. There are 2 subsequent orders of this honorable court. After the first order passed in my case also.
Just that order is.
All right, let us see Tarsam Singh.
You have the decision in that same thing.
But I have not got that. But in the year 2008, 3 SEC.
Do you have a copy?
Take up Monday, I'll file all those judgments. Yesterday, I have given to Lordship Valnath Mahapatra's judgment, which has been upheld by the Supreme Court. Now, can I take leave, my lord, from this honorable court, my lord, to file a review for the honorable single judge?
That can be done.
But if I give that review so that it will be better, my lord, I'll persuade my lords to.
That you may try.
But unless your lords permit, my lord,
And counsel for the petitioner, after some argument, seeks permission to withdraw this appeal with the liberty to prefer a review application seeking review of the order passed by the learned single judge, which is under challenge.
You want to file a review against which order?
last order.
Not the first one.
No, no, first order. Because I will persuade my lords, my lord, to accept because there are 2 subsequent orders of this honorable.
In the present appeal, as according to him, certain Supreme Court's decisions could not be brought to the notice of the learned single judge, which were relevant for just adjudication of the dispute involved. This application, this appeal is dismissed as withdrawn with the liberty as sought for.
Item number 7.
May I please, my lord? My lord, in this case, one rule is made unfair in the recruitment conditions rule, your lordship. And using that unfair rule, your lordship, mandatory provisions has been violated and promotions have been given to range officers without having the requisite qualifications and without completing the mandatory 5 years tenure in their cadre. And they have been promoted to the rank of assistant conservator of forest.
You see, there are 2 aspects. Either you challenge the virus, either you challenge the virus, or you seek any other relief. Both you cannot do parallelly. Because you are challenging the virus and at the same time you are trying to get some relief under in accordance with the rules. No.
One provision of the rule I am challenging. Only one provision of the rule.
All right. So your case has to be considered without taking into account that rule.
No, my lord. Because of that particular rule that has been made unreasonable, taking the aid of that particular unreasonable.
All right, let us see the rules.
My lord. My lord, the rule is the 2013 recruitment rule, your lordship.
All right.
My lord, it starts from page number 61, your lordship. The specific rule that is impugned is rule number 4, your lordship.
60?
It starts from 61, your lordship.
Yes.
The relevant one is the next page, that is 62, your lordship.
Yes.
Method of recruitment, your lordship.
Yes.
Your lordship, the 4A and B, they determine the percentage of recruits that will be recruited through direct recruitment and through promotional recruitment, your lordship.
Yes.
In this case,
so you are challenging this provision.
My lord, because using this particular provision, only by using this provision, this particular provision, they have expanded the zone of consideration of the feeder cadre.
That is there.
And use that to give promotion by relaxing the mandatory qualifications that they should have met before being promoted to the rank of the petitioners. And in violation of those rules, they have been promoted and have been placed ahead of the.
No, forget that. What has happened? You have the rules. We have the rules before us. This rule violates which provision of the Constitution, which provision of any law, which provision of any overriding rule.
My humble submission is this provision is inconsistent with the rule itself because of the other.
All right. Which provision?
This says that direct recruitments will be 33% and promotional recruitments would be 66%. If that is the case, actually it was in its earlier avatar, it was just the reverse. The direct recruitments were to be 66% and the promotional recruitments were to be 33%. This flip has been made without not in consonance with
you
the
are direct or promoted?
Direct, my lord.
You are direct.
My lord.
So you have entered into service or outside the service?
I have entered into the service.
Then what difficulty?
Because by using
this, you are unnecessarily wasting the court's time. In such matters, we are not required. The simple formula is that 1/3 of the posts are to be filled up by direct recruitment and 2/3 by promotion. What is wrong in it?
My lord, on the face of it, nothing looks wrong to be, my lord. The previous version, it was just the reverse.
Maybe.
My lord. Now they have, after flipping this, using this particular, only this provision, that there are, this number of posts need to be filled up. They have given relaxation, which is not mandatory, Your Lordship. Your Lordship, they have given relaxation to the feeder cadre post personnel and promoted them ahead of their time without meeting the qualifications just to meet this particular rule.
That can happen.
My lord. So that is and they have been placed ahead of the petitioners in the gradation list and further promotions have been given, Your Lordship. Therefore, the provisions have been, the mandatory provisions have been violated of this principle. And the rationale for violating those mandatory principles is used this particular unreasonable flip. That is what is my humble submission. This rule I need not challenge because I have already come into the cadre. Your Lordship is correct. But the anomalies they are creating only with the aid of this particular rule.
Suppose this is applied from retrospective effect. Then you go out?
No, I don't go out. I'm recruited even within 33%. I'm recruited as such within that. I will not go out on that.
Sorry. No merit. The petitioners in the present writ application have put to challenge Rule 4 bracketed A and Rule 4 bracketed B of Odisha Forest Service, Group A, bracketed Junior Branch, Recruitment and Condition of Service Rules 2013. Most of the said provisions read as under 4A and 4B. Most of the petitioners petitioners were recruited to the cadre of Assistant Conservator of Forests, OFS Group A bracketed JB, through direct recruitment, that is in accordance with Rule 4 bracketed A. Stop. They have a grievance that because it is their case that when were those provisions there?
The other provision, yes. 1984 rules, Your Lordship.
That before coming into force of 2013 rule, the service in question was the Forest Service or the OFS?
Orissa Forest Service.
The recruitment process for OFS bracketed JB cadre was governed by same rules 1984.
My lord.
Wherein the 66% of posts, according to which 66% or 66 point what? 66.67% of
66.33, 66 and 33.33. That is.
And what about the rest?
My lord. This 66 and 1/3 and 33.
As nearly what not. Okay. 66.66 posts were to be filled up from direct recruitment and the
Earlier one was that.
Earlier one was 66.1/3 were direct recruitment and 33 were promoted.
My lord, the earlier rule 84, the entry grade was class 2. Here the entry grade is group A junior branch.
That is just the upgradation given to that particular cadre. No, nothing changed. Only the upgradation.
And rest by way of promotion.
Right.
When counsel appearing on behalf of the petitioners challenging the aforesaid rules 4 bracketed A and 4B of the rules of 2013 has submitted that because of higher percent of reservation, higher percent
allocation
of posts allocated, because more number of posts to the extent of 66%, 66.66% are now to be filled up by way of promotion, comma, the persons selected through direct recruitment are getting adversely affected. So stop. He submits, where is the relaxation?
My lord.
Relaxation you are saying?
They have given a number of relaxations. Particularly they have violated the rules. The relaxation that are the qualification that they have violated is at rule 14, your lordship.
That is different. That
Annexure 10 is
66
one of the relaxation, page 94. Annexure 10.
No, that relaxation is accordance with the rules.
In accordance with the rules.
So which is the provision provided?
Provision rule 24 of the 13 rule, your lordship, my kindness. Rule 24 of the 13 rules.
He has argued that the rule 26 of the rules, 24 of the rules provides for a relaxation of any of the provision of these rules in public interest in consultation with the Odisha Public Service Commission, comma, if it is found necessary or experience to do so. So stop. He contends that taking advantage of he contends that the said provision under Rule 24 has been unreasonably exercised to to extend promotion against 66%, 66.6% of quota from the feeder cartel.
Right.
Stop. He has accordingly submitted that since because of the provision under 4 bracketed B of the rules, the prospect of direct recruits has been adversely affected, comma, this court's interference is required by declaring the said provision ultra vires. So stop. Next, we are not convinced with the submission so advanced on behalf of the petitioners. So stop. The said provision does not violate any provision under the Constitution, including Articles 14 and 16 thereof. Stop. Nothing has been drawn, no other statutory provision has been brought to our notice which has been violated because of the nature of provision under Rule 4 bracketed A or 4 bracketed B of the rules. Stop. We accordingly do not find any merit in this application, which is accordingly dismissed.
My lord, may kindly be allowed to pursue my remedy, otherwise.
It goes without which remedy?
That the gradation list that they have.
We make it clear that if then the petitioners shall be at liberty to approach appropriate authority if according to them they have been adversely affected by promotion granted to any individual or group of individuals in violation of breach of the rules, as we have not gone into this such contentions raised in the present writ petition. So we expect, however, that the concerned authorities shall take into account in correct perspective the stand taken on behalf of the issue raised on behalf of the petitioners, that Rule 24 of the rules is being exercised without account without unreasonably being exercised in some of the cases, though it mandates that such power can be exercised only when the government is of the opinion that it is necessary or expedient to do so, comma, in public interest, comma, in consultation with the Orissa Public Service Commission. All right.
May I pray one thing, Lord? My Lord, here all the promotion orders, the DPC proceedings he has enclosed, and those proceedings have been given effect after finalization of the gradation list. Now, if they will raise any objection at this stage, even after 4 years, 3 years of relaxation,
that can
then
be rejected on that ground.
So the persons likely to be affected may also be given that opportunity to have their say in the matter.
That goes without saying. See, we have not done anything because minus virus, the bench should not entertain any other grievance.
Much okay.
So the argument has been made. You will see, and that opportunity see. Everyone has a right to write a letter. It is up to the other side. All right.
Also file a writ petition even if there is no case.
So that right is there. File a writ petition, write a letter. That can be done. These days, send an email also.
There are other problems as well, but I'll oblige.
Item number 8.
Item 8, matter relating to the virus, question the validity, that is block grant order that. Your lordship had and this judgment is reserved. Did it come, my lord, after the delivery of the judgment?
That matter, my lord, regarding that Anup Senapati
Yes,
case.
yes. My lords.
Not getting time. Right. Only one item.
Yes, my lord, one item. That is 8.
On this matter after 4 weeks. Yes.
Item 9.
My lord, this is regarding that
40%
INC guideline. INC guideline regarding 40% of the SC/ST category, my lord. I have got the instructions because you could pause your time. My instruction is, we will allow all the candidates of the institutions who have admitted students, as per the INC guideline for SC/ST category, we will allow their admissions. But they have to get permission from the university to appear in the examination. We will admit all the students. That is my submission.
Just to add to what my friend had stated, if your lordships can grant us the liberty to write to the university by virtue of an affidavit also, because tomorrow the exams, so we can submit it today itself through an affidavit. Because enough time is there, we can do that, because otherwise getting the order copy and then Lord sending might be too late. So that
What you are saying, have you communicated to the university?
No, my lord, university I am not the advocate for.
No, you are not the advocate, but your decision.
No, your lordship with order, we will
unless my lord gives a direction, we cannot give an instruction.
So we'll submit an
court
affidavit.
Give you the direction.
Court can give other directions. Not keeping it in the guidelines. Where is Mr. Sethi? You are there. Not the instruction.
No, because
oral instruction.
Yes. That can be, my submission can be recorded.
What is that guideline? 50%?
That is INC's guideline, if your lordship.
Number
6, page 33, my lords.
What is that?
Annexure 2. There is guidelines and minimum requirement to establish BSc Nursing College of Nursing. And in that, clause number 7 and 8. Well, 7 and 8, the two relevant clauses. At page 37, if your lordship would see, page 37 and 38.
The Indian Nursing Council is admittedly a regulatory body which regulates inter alia admission to the nursing courses by laying down guidelines for the said purpose. Where is that rule? 7?
7 and 8, my lord. 7 is the percentile.
What is the date of those guidelines?
Lord, that 6/4/22, but that is not 20, but it is not mentioned here.
It's not there in
6/4/23.
those guidelines.
My lord, that date is not mentioned, but it is on.
Mr. Mahanti, you don't dispute that it is
No,
6/4/2022.
it has been done. I don't dispute.
22, it was, my lord,
There is no date in that.
decided, but on 6/4/23 notified.
23, it is notified. So the 23, when it came, by that time we have already gone now.
Guidelines are
The-
framed in 22, but notified.
Our attention has been drawn to such guidelines which relate to admission terms and conditions. Clause 8 of which is the reservation policy and reads as under 8 quote from paragraph page 38. Oh, stop. Apparently, the candidates belonging to SC, ST, OBC categories were to be given relaxation in terms of the percentile to qualify for admission to which course? GNM
BSc
course.
nursing.
nursing.
BSc nursing.
BSc nursing course. So stop. It may be noted that the minimum qualifying criteria for entrance test of entrance test to admission to BSc nursing for general candidates has been prescribed as 50th percentile, general PWD 45th percentile, and SC, ST, OBC 40th percentile. So stop. So stop. Next. The DM, what is that? DMET?
Director Medical
Director-
Education and Training.
Yes.
Director
Medical Education and Training.
Medical Education and Training, Orissa, had issued a prospectus for admission to BSc nursing course. So stop. The relaxation aspect in respect of candidates belonging to SC, ST, OBC in terms of marks obtained in 3 core subjects was not mentioned in the
Guideline.
said prospectus.
Yes.
So stop. Next. The petitioner in the present case is a nursing institution.
Yes.
Nursing institute imparting BSc nursing courses. So stop. It has admitted students applying the reservation policy.
The relaxation policy.
Relaxation policy. Reservation, that is the
And-
part
and-
of that.
Yes.
Reservation. Reservation and relaxation. क्या लिखा है? Applying the reservation and relaxation as prescribed by the INC in its INC as noted above, as quoted above. So stop. The students admitted on the basis of application of rule or / policy, policy under clause 8 of the INC guidelines are not being allowed to appear for the university examination, which is
My lord,
scheduled
I
to
may
commence.
they have not been admitted yet. We have not allowed their admission.
They have been admitted, but that they have not approved it.
Approved their admission.
All right. Commence from tomorrow because the DMET has not approved their admission. So stop. Learned counsel for the DMET on instructions this court that there being specific INC guidelines, they are not opposed to the act of the petitioner in admitting the students, giving the relaxation provided under clause 8 of the guidelines.
7 and 8.
7 and 8.
7 and 8.
8 of the guidelines. 8.
The
See,
post-
there is
yes.
difference between
Yes,
7 and
percentile and that they're the qualifying.
Yes.
there it is percentile, here it is marks.
Marks.
So that is the difference.
Yes.
Even if they don't fall in the percentile, but
They can.
if they have obtained that
Marks.
mark, they are entitled. By giving them a yeah, right. So accordingly, so how will you approve?
We will immediately approve that. We will instruct them for approving their admission, and we will inform the university also immediately.
He submits that the DMET shall take prompt steps to approve such admissions.
Yes.
When will you do it? Today?
Today, if I get this, I will get it today. Today afternoon.
How many students?
9 students. 9 students.
Next, Mr. Nandal, senior counsel appearing on behalf of the. So will you approach the university?
I will also, my lord, by way of submitting an affidavit that this is the view of the, like on the basis of their submission, your lordships have passed this order, so they may be.
Get the order today.
If we get the order, my lord, then.
Today we take the order. Yes. I have filed the application.
Such view of the matter. But how will you fill up your application forms?
Well, they can do it, my lord. That's the colleges, they will assess the students.
Examination forms.
Already there, my lord.
Examination forms are there.
They're there already.
Stop. In view of the stand taken on behalf of the DMET as noted above, we are of the view that the university should allow the students of the petitioner who have been admitted by giving them benefit of a reservation / relaxation under clause 8 of the 8 of the INC guidelines.
My lord. My lord, I may interpret, my lord.
Admitted by.
My lord, I may interpret. Suppose they are not supposed to get that admission, this examination this time, we are having supplementary. We can allow them in the supplementary also. If time doesn't permit, we can allow them in the supplementary to sit in the examinations.
Do it. Why can't you?
No, my lord. University, I will inform university, but the form fill up, all these things will come. That's what I'm thinking.
Right? They can do it. Let them do it.
Yes, sir.
Yes.
1 week. Oh, stop. We have been informed at the bar that some other institutions, other colleges, nursing colleges have admitted students giving benefit of the students of various categories giving benefit of the aforesaid clause 8 of the INC guidelines. First off, it is expected that the DMET shall issue appropriate approval orders.
Are all the issues.
Huh?
Yes, my lord.
Shall take appropriate steps in their cases also. First off, what is your case?
My case, WPC.
Give him the case, the name of the college.
I have already given.
On
He has given me copy.
1 week. Stop. 1 week along with the WJC, WPC.
16991. 2024.
Yes.
My lord, may I submit a small prayer, my lord? I have got two similar matters, as your lordship has already said.
There are some matters are also there.
I have got two similar matters, 10137 by 2024 and 10144 by 2024.
Give the details to.
I have already given, and I have also yesterday called my learned senior.
Therefore,
also.
that order is there.
Only your lordship, along with this order, my order may be tagged so that 10137 by 2024.
No, that we will not do. Your case is not on the list. Therefore, we have made this general observation.
Lordship, if we can get the order copy today, we
will get it.
My lord. Your lordship may kindly consider to direct my learned senior for allowing my students also, only 3 students.
General Lord, I will take care of that.
Obliged.
Please, ma'am.
Item number 10.
Right, please, ma'am. My lord, before I proceed to the impugned order, can I summarize the facts, my lord? My lord.
Yes.
On 1/6/2023, Annexure 4, my lord, is the tender notice, my lord. Is the hiring of payloaders and tippers for mechanical transportation and transportation of coal from coal faces to stocks. This was floated by Manadi Coalfields, my lord.
Yes.
And I participated in this tender, my lord. Thereafter, my lord.
Yes.
Thereafter, my lord, page 188, Annexure 5. They asked me to extend my bid validity. As per the Annexure 5, 188. My lord, they asked me, the MCL asked me to. So
the work was awarded to you.
My lord, sorry.
The work was awarded to you.
Yes, my lord. Ultimately, it was awarded to me after, my lord, extension of validity of my bid period for 1 year, my lord. Thereafter, my lord, the LOA was issued to me. Kindly see, my lord, this why I am relying upon this bid validity extension letter, my lord. I want to read it out. As per the terms and condition of NIT 878, the validity of the bid of the tender, that is 120 days from the last date of submission, that is 15/7/2023. Therefore, the validity of the bid is up to 12/11/2023. Since your offer is still under examination and may take some more time for finalization, you are requested to extend the bid validity by 90 more days, and line of confirmation of above may be please communicated to office or before 12/11/2023 positively, and same has to be confirmed through GM portal, my lord. And we have given our confirmation, my lord. My lord, in this way, my lord, the last extension was issued to me on 6/5/2024 for another period of 91 days, my lord. Thereafter, my lord, while this bid validity was there, my lord, they issued the LOA to me, my lord. Annexure 8A, 8 series, my lord. It was issued to me on 29/6/2024, my lord, after 1 year. Thereafter, my lord, I wrote a representation to the authorities on 8/7/2024, asking that
because there was an abnormal delay in the award of the contract, and you please change my rates, revise my rates and issue a fresh LOA, or I will take an exit from the tender, my lord. While, my lord, I gave this representation, they disposed of my representation, my lord. Right, annexure 1, my lord, page 23. Can I read it?
Yes.
You have participated in the above subject tender and emerged as L1 bidder by quoting a value of 59 of the estimated value of GST at the rate 18%. Accordingly, you have been awarded the contract as per clause 20 of instruction of bidder, and you have been electronically notified regarding the award of contract in your favor through GM portal as per clause 23 of instruction to bidders. The subject tender was invited on 1/6/2023 with the last date of submission of the bid up to 15/7/2023. The initial validity of 120 days up to 12/11/2023. On 15/7/2023, technical bid was opened. It was observed that you, along with 5 other bidders, have participated in this tender. A writ petition was filed by one of the ESM companies. This is my lord. Ex-military companies, my lord, engaged in loading and transportation of work at Jagannath OCP in the Honorable High Court of Orissa by WPC number 18763 of 2023, praying for cancellation of this tender under NIT 878. The Honorable High Court of Orissa, in its order dated 13/6/2023, directed not to proceed with the tender till the final decision of the writ petition. In view of the above directive from Honorable High Court of Orissa, the further processing the subject tender was not possible, and all the participating bidders were requested to extend the bid.
Where is your LOA?
My lord, LOA is at Annexure 8, my lord. 29/6/2024, 191 page, my lord. My lord, my submission is this: while you extended the bid validity, you have never informed that there was a case pending in this regard with this NIT, my lord. Now, if there would have been a information to me, then I would have exited from the bid.
So
now,
they suppress that fact.
Yes, my lord, they suppress that fact, my lord.
That is your case.
My lord. And secondly, my lord, with this 1 year has lapsed, my lord, and the time is the essence of the contract. So there has to be a change in the rates at least. So without, and that particular representation, my lord, if my lord will see the representation for a moment. No, we have not filed. Oh, that, my lord, prior to the, at the time of representation.
How can you make this submission?
My lord.
That a writ petition was filed that was suppressed.
It's not, my lord, suppressed. They have never communicated that thing to me.
Never communicated. You must be knowing.
My lord, but they should know, but they should tell us, my lord.
You filed an affidavit that you were not knowing. We will consider your case. And counsel appearing on behalf of the petitioner has stated that in relation to the tender in question, a writ petition was filed by WPC number so and so. Stop. In the so and so, wherein an interim order was passed. Stop. The petitioner did not have any knowledge about the interim order, which fact was suppressed by Mahanadi Coalfields. Let an additional affidavit be filed in this regard, stating that it was not within the knowledge of the petitioner that said WPC number was filed and pending before this. So, file it. How much time will you take?
My lord, 1 week. 1 week time.
1 week.
What is that writ petition you mentioned in the cause titles?
Cause title, my lord, that
You
was
will also
It was with regard to before the impugned order has passed, my lord, on basis of the representation.
Just file it.
Might.
File it that it was suppressed
Might.
and you did not have any knowledge about the in any manner.
Might.
If that statement is found to be false, the court will proceed against you. All right, you can tell your client.
Item 11.
May I please, Your Lordship? Similar to the petitioner challenging one of the tender condition, but the tender call notice is at page 20.
Tender conditions.
My lord.
So you are yet to submit your bid.
Yes.
Before that, you are challenging the tender condition, then don't participate.
It affects my right to do a business, my lord.
All right.
Me and my brother.
All right, let us see.
Annexer 1, my lord, page 20.
Yes.
This is the tender call notice for appointment of district level transporting agent.
So which is the condition?
My lord, page 35.
Page 35.
Yes, my lord. This is one of the annexers to the tender call notice.
Right.
A bidder need to say, submit this declaration.
Yes.
Below the table, I am aware of the fact that the term family shall mean I am agreed by clause 4.
Yes, yes.
Full blood siblings, within bracket, brothers and sisters from common parents and their spouse. Me and my elder brother and may read
yes, they appears to be right. They are debarred from participating. Are they debarred?
No, only to avoid the monopoly, my lord. Monopoly and black market.
Monopoly, yes. Parent, husband, wife, sons, daughters, all right.
My lord.
But how full brothers?
And their spouses.
They file.
My lord, that part, my lord, I will file a counter affidavit.
Filing your counter affidavit. 2 weeks. 2 weeks.
My lord.
2 weeks time is allowed for the opposite parties to file a counter affidavit. If you notice, if you receives notice. At least this clause should go, Mr.
Yeah.
Yes, on 2 weeks. Yes, sir.
Yes, I have to pray, my lord, let the tender process go on. Let there be no finality to that.
No, finality will be there. In the meanwhile, so the tender process may continue, the final outcome shall be subject to final result of this case.
For orders item number 12.
Listen, item number 12, the state has filed a review, my lords, and there is a defect that we have not filed the impugned certified copy of the impugned order, my lords.
My lord, those. Sorry, my lord, just these things have been before Honorable Supreme Court. The proceeding has been stayed by Honorable Supreme Court. The matter
99.
My lord.
This is 99 matter.
Yes, my lord. Now.
No, 99 matter, my lord, disposed of in 2012. Subsequently, we filed a review stating there is that a review was allowed on the basis of a document filed by the petitioners, which is a fraudulent document.
No, my lord, review. Sorry.
And that is our ground, my lords. And to substantiate that, we have filed documents saying that on that the letter which has been signed in the name of the officer, he was never appointed there. So that is the ground of review. Now, but my friends.
No, what happened thereafter? Review was allowed.
No, review was allowed, and we have challenged that order, the review order in another review application filed by the state.
No, the first order was passed by which court?
This honorable court.
First order passed by this court. Thereafter?
Subsequently, review was filed by the petitioners.
By the petitioners.
Review was allowed by this honorable court.
On what ground the review was filed?
Review was filed on the ground that it is Urban Land Ceiling Act. And the proceeding, the state government has found that 19 some acres of the land of the petitioner was found to be surplus. So it should have been vested with the state government. State government should have taken possession. But so they filed a review stating therein that as per that, because the act was repealed. So they filed a review application stating that on the basis of that order, state government has not taken over possession. So they are in possession. That is why the land cannot vest to the state government. They should be declared to be the rightful owners. And they filed a document of the year 2003 stating that in that the Tahsildar was directed by one of the government officials to take over possession, to substantiate that the possession has not been taken over since 1999. So the review was allowed, stating that the possession has not been taken over by the state government. So the review was allowed. And we have filed another review stating that that document is a fraudulent document. So notice was issued. My friend has appeared.
Then what happens?
No, now it's pending before lawsuit.
Second review.
Yeah.
The second review application.
Yes,
is
REIT
pending.
application is also pending. Review is also pending. They are REIT application.
Oh, so that when the review was allowed,
Yes.
this OJC stood restored.
Yes.
Because of the order passed in review application.
Yes.
This OJC was restored or what happened?
So this was allowed, OJC was allowed,
All right. OJC was allowed.
So we have filed an IA in the OJC to recall that order, but because IA is not there, we have filed a review application. That review is also along with that.
There is some confusion.
No, again,
See, one writ petition was filed.
Yes.
By Fakir Charan Singh.
Right,
This is OJC 7386 of 1999.
99,
In this case, some order was passed.
Yes,
Seeking review of that order, a review application was filed by Fakir Charan Singh.
Right,
All right. That review application was allowed.
Yes,
After that review application, you file another review application.
Yes,
State filed another review application. That the basis on which the review application was filed was fraudulent document. Where is that review application?
That our review application is connected, is there in the list.
It's connected there.
Yes.
But why this OJC has been listed? Because OJC, according to you, was disposed of.
Yes, we have filed an interim application IA to recall the order in the OJC. That's why it has been listed.
OJC, so OJC is disposed of.
Yeah.
All right.
Read report as it is.
There are two petitions.
Yes.
There are two.
There are two.
Because if lordship sees the order sheet.
Now we can explain. Yes.
OJC
So this is what we have understood.
My lord, can I submit, my lord? First, my lord, OJC, my lord, 7386 of 2099 was passed, my lord. It was disposed of, then a review was filed, it was restored back. Thereafter, my lord,
WP. Just a minute.
Sorry, my
So when you filed your review application,
lord.
the OJC was restored.
Yes, my lord, it was restored, and thereafter, my lord, thereafter, my lord, WPC 13313 of 2005, both these applications were heard together.
So what is this 2005?
2005 was another writ application, my lord, was filed by the same writ petitioner.
Why?
My lord, for that declaration of that sealing act to be amendment of sealing act has to be applicable, so that the possession was not taken over by the government, so it should be restored back to the petitioners. The land has to be restored back to the position, because, my lord, the applicability.
So there are two writ petitions
Yes, my lord.
pending.
No, my lord, what has happened? Just I will clarify, my lord. These two writ petition got disposed of in 2012, stating that all the lands, the amendment to the sealing act is applicable to the petitioner case, and petitioner land has to be restored back from the government to the petitioner. Thereafter, my lords, the state went before Honorable Supreme Court. Honorable Supreme Court, my lord, issued notice and SLP. Thereafter, my lord, SLP was converted into a civil appeal. In the civil appeal, a detailed order was passed dismissing their SLP, my lord, state SLP. Then state filed a review application before Honorable Supreme Court. That review application was also dismissed, my lord. Thereafter, my lord, one of the brother of the petitioner moved a writ petition asking Honorable Court to restore my land, to convert the ROS into, which was in the name of the government, my lord, to convert it to the petitioner name, my lord. In that, my lord, when it was not done by them, they filed the brothers of the petitioners filed a contempt application. There, my lord, from there they filed 2 IA, my lord. One IA was for the review of the 2012 order and another IA for the state file, my lord. So one for the stay of that 2012 order and one was filed for review of that 2012 order judgment, my lord. So one IA was allowed to be filed in a form of a review and second IA, my lord, order was passed to stay the 2012 order. Against that order, my lord, we went before Honorable Supreme Court saying that how after so many years, when the review by Honorable Supreme Court has been dismissed, how can they file another review? On that ground, my lord, Honorable Supreme Court issued notice and stayed the proceeding of those 2 IAs, my lord. Now, meantime, they also, while pendency of that SLB, my lord, they also moved, they filed a registered an FIR against us. That FIR has also been stayed by Honorable Supreme Court.
Where is the order?
My lord, this is the order. These 2 others, my lord, here the interim orders are there, which has been extended. Matter is
Where
coming
is the
on.
order?
My lord, those orders. My lord, this is the order, first order by the SLP, my lord. Here in this SLP order, I just give my lord, give me. These are the orders passed in that SLP.
No,
This
no,
is the
what is the
review order, my lord.
Oh, no, Mr. Counsel, see, there is a second review application pending.
My lord.
According to you, the Supreme Court has stayed the
Yes,
second
my lord.
review.
Yes,
Where
my
is that order?
That order, my lord, I'll give you just my lord. I'll give you that one. If my lord will take up at 2 o'clock, I'll.
Tomorrow.
Tomorrow.
Item number 13. Lordship, I am for the sole respondent. Filing today, I am filing the affidavit.
Affidavit for?
Affidavit is with regarding the status of the deceased employee, that he was a regular employee at the time of death.
Your objection.
My lord, may I pray this matter may be taken up next week? On this affidavit, I have to take instruction.
All right. Okay. As requested on behalf of the appellant, let this matter on 1 week. What is this affidavit about?
What is the why he has filed this affidavit? On last occasion, remember this matter that he has relied on judgment. Relying that judgment, this case was disposed of. I have shown the document filed by him, the read petition. In the read petition, he has stated that he was a temporary employee. But in this affidavit, he has included some documents showing that he was a regular employee.
All right.
Item 14.
In item 14, already notice has been issued. And noting with that
Affidavit. Nobody has appeared.
no one has appeared. Postal is showing that item delivered.
Nobody has appeared. Is this connected with any?
It's not connected, but other matters are, this is regarding that RACP matter. Other matters before Honorable Apex Court stay has been granted. So it can be taken up after some days. Admitted fact, there is a delay of 360 days.
Yes, sir.
I have requested on behalf of the appellant, let this matter on 8 weeks.
Item 15.
In item 15, my learned friend has appeared and has filed an objection to that.
Filed the objection, my lord. You do, my lord. I saw the copy. Yeah, yes, I will solve.
This side.
Other side, separate with that. Sorry. I solved the copy, so let it come 2 weeks after. Let it come 2 weeks after, you will also.
No, objection you have served. He should ask for time, not you.
I mean, your lordship also, I filed today. Not your lordship's brief also. That objection.
My learned friend has filed an objection to my limitation petition. That is 128 days delay, lordship.
So your lordship, that is also not your lordship's brief, my lord. So let it come in next week or any other.
Let the objection said to have been filed on behalf of the respondent to petition be placed on record on next week. All right.
When did you receive the notice?
3 days back from the client. He's very ill and it's.
You are Mr. Swine?
Mr. Prasanna Kumar Sahu.
At a co-item.
60.
Sorry.
I'm just appearing today.
All right. So we'll keep it here or there?
File it in the registry.
Mr. Prasanna Kumar Sahu, learned counsel, submits that he has instructions to appear on behalf of the respondent and shall file wakalatnama in the registry in course of the day. He prays for 4 weeks' time to file an objection to the IA for condemnation of delay. Full stop. List the case. Date the
2 weeks, 7, 8.
4.
41st.
21/8/2024.
22nd August, your lordship have kept the similar matter that not
All
the
right.
Pradhan.
List the case on 22/8/2024. Objection, if any, shall be filed by 16/8/2024.
Okay.
After serving copy on the learned counsel of the appellant.
Item 17.
My lord, I have filed an application for modification of your lordship's order, my lord. But, in fact, the recruitment process was started in the year 2001, my lord. And the other persons, those who are, my lord, along with the prisoner.
No, the writ appeal was disposed of.
Disposed of, my lord.
There's some typographical error.
Yes, that 2 years that your lordship may say 2001, that will be 2003.
Page.
Page, my lord, page 2 of the order, paragraph 7, my lord. Second line. In place of 2005, it will be 2001, my lord. And then your lordship can see paragraph 8. Last line. In place of 2005, it will be 2003 when the other persons were recruited. And you also can see page 10. Sorry, paragraph 10, page 3.
Yes.
Paragraph 10, last line, my lord. In place of 2005, it will be 2003. And page, my lord, page 6, my lord, paragraph 16, my lord, 5th line. In place of 2005, it will be 2003, my lord. That one.
Do you have a small slip?
There would a urgent slip.
No. So many slip. There are so many corrections required.
Yes, I'll give.
Can you give it right now?
Yes.
Just note that.
So, Mr. Khuntia, you also agree that those corrections are
Yes, paragraph 3, he has stated in paragraph 3.
Paragraph 3.
Well,
All the corrections are in paragraph 3.
my lord.
Huh?
My lord.
Mr. Counsel, all the corrections are there in paragraph 3.
Yes, para 8.
So you will not file another application for modification.
No, sorry, my lord. I have written paragraph 3.
Paragraph 3, everything is there.
I have written.
And our attention has been drawn. IE number 5402 of 2024. This application has been filed in the wake of certain typographical errors which have occurred in the judgment and order dated 5/7/2024, passed in
15/7.
15/7/2024, passed in WA number 724 of 2024. Stop. Learned counsel appearing on behalf of the respondent.
Is respondent.
On behalf of the respondent in the writ appeal has rightly pointed out the typographical errors in the said order,
Paragraphs can be mentioned.
paragraph 3 of which reads thus. IE number. Full stop. Accordingly, it is ordered that let 2001 quote unquote be read in place of 2005 in paragraph 7, comma 2003 be read in place of 2005 in paragraph 8, and
10 and 16.
2003 be read in place of 2005 in paragraphs 10 and 16.
So the same thing in 8, 10 and 16.
8, 10 and 16. 8, 10 and 16. 8, 10 and 16, it should be 2003 in place of 2005. So, usko लगाने, in place of 2005. Stop. Next, it is accordingly ordered that this court's order dated 15/7/2024 be read accordingly along with the present order. Stop. How that will be incorporated? Let the let the order be corrected accordingly and corrected and uploaded and be uploaded accordingly.
May I pray one thing, my lord? Lord, in the writ appeal, your lordship has not fixed any time. I have prayed, my lord, a specific time may be, my lord, given to exercise the, in the.
These are clerical errors, therefore we have.
In this I have also prayed, my lord, to complete the entire exercise within a specific time. That is.
If they don't do, come later. Maybe our mistake, but
yes. In addition, I have prayed for.
Item number 18.
In item 18, your lordship has issued notice on 19/6/2024. My learned friend has appeared in this case. That is.
Mr. Mishra is there.
My lord, I have received the notice and I have entered appearance, my lord.
62 days delay.
My lord, your lordship may consider the delay, but the fact is that except departmental move of file from one section to another, nothing has been pleaded.
All right.
Have they pleaded would have been unusual.
My lord, only that from one department to another department file has moved. This is what they have stated and no reasons at all. And it is well settled that that cannot be a ground to condone the delay.
All right.
This is also a covered case of my lords also.
Sorry?
This is also covered case that lordship that during pendency of vigilance case, Direction.
We'll see. Let us condone the delay.
That is, that again, your lordship, different judgment has also been passed by this honorable court. My lord, my lord.
62 days. 62.
62 days.
And we are convinced that it is in the interest of justice, it would be expedient in the interest of justice to condone the delay in fact. The delay is condoned, the eviction will be allowed and disposed of. The case for fresh eviction on
Any day, your lordship.
7.
Or if one similar matter is coming for tomorrow. It can come tomorrow, I can also.
No, let it come after some time.
Mal.
Have you received a copy of the appeal?
Yes. No, my lord. No, my lord. Only the limitation petition copy I have received.
I'll serve in course of the day.
Yeah,
Well,
by tomorrow.
by tomorrow.
Your lordship would be kind enough to impose some cost, my lord, because of the condonation of the delay.
25 rupees.
No, my lord,
In fact,
obliged.
they deserve some award for filing the appeal so quickly.
Obliged, my lord.
Item number 19.
Obliged.
There has been delay of 138 days in filing the appeal, madam.
130.
138 days.
But lordship, here in this writ appeal, lordship, against interim order of this honorable court. Because the pendency of this writ appeal, the Lord and Single lordship, honorable single lordship, kindly two orders, lordship. Because lordship kindly see in writ petition.
So my learned friend is going to the merit of the case.
No, not I'm going to minister of the case. Here I'm showing your conduct.
Chorus.
Sorry.
Don't argue in chorus.
Sorry, lordship.
Let's say this appeal has been preferred against the order of interim order. Your
Lordship,
lordship.
kindly see two orders, sir. No, sorry, lordship.
Where is the order which you have challenged?
Yeah, pays 150, your lordship. Yes, madam. According to lordship, read petition, counter, everything has been annexed.
So you challenged this order?
Yes, madam.
How much cost will you pay?
My lord, what happened, my lord?
How
Here
much
the
cost
transport
will you pay?
for challenging this order.
Yes.
My lord, transport order has been stayed, madam. Here, your lordship, this no, well, but that means we are not in a position to transfer this person.
All right, very good. So, did you make any application for vacating the order of stay?
Yes, counter has already been filed, your lordship.
Have you filed any application for vacating the
Yes,
order
madam.
of stay?
Yes, madam.
Huh?
Yes, my lord.
Did you press that?
Yes, madam. We have, your lordship may see.
See, we intend to impose exemplary cost. This is not the way.
Question then answer. Have you pressed your application for vacation of stay?
Not in a position to answer because of that. Because my lordship, the certain things are there. We have filed memo, but it's not being listed. But because of your lordship knows that I.
We don't know anything. You have filed an IA?
Yes, my for interim for vacation. Yes.
And this order, Mr.
Yes, ma'am.
Counsel, have you read 226(3)?
Yes, madam. That your lordship, what made me approach this honorable court, my lord. Your lordship is absolutely correct that against interim order, we are normally not filing any writ appeal.
Examine 226, read Article 226. I might have forgotten.
Then he is not read.
No, normally we don't file, my lord, but with the yes. Yes, but vacation of entry bond is to be filed.
Huh?
Vacation of entry bond is to be filed.
Read it.
Where any
I know, Lord, but here is
Where
not
any
like a
party-
transfer, Lordship. I am praying for transfer because they threat me to withdraw the application. This court give me protection not to take coercive action. They have filed counter. The Honorable Singh is ready to hear
What
this
coercive
matter.
action? Will they beat you up? Coercive action, they have transferred you, you are also interested in transfer.
No, Lordship, I am there.
See, this order has lost its force.
Lordship,
Then
Lordship, then. And Honorable Single is eagerly waiting to complete this proceeding, Lordship. Can I see to last order? No, Lordship, sorry, Lordship, because Lordship, sorry, I'm ordering my language, Lordship. Lordship, because there is two, and pleadings are ready.
All right.
Because they made a mention, writ application pending will not.
direct the writ petition where pending with the citizens.
Learn counsel for the appellant. After some argument seeks permission to withdraw this appeal, which stands disposed of accordingly.
Lordship, direct the petition may be disposed of. Writ petition may be disposed of.
No requirement of any kind.
Adjournment.
No, I have not taken it.
Yes, that ought to do us.
Odds.
Item number 20. May it please your lords. Here the point of law is very limited. A amended provision has been applied retrospectively in absence of its retrospective application. That is my first point of submission. I have filed a written note of submission. If my lord kind enough to refer to that, that will be easier for disposal. All three matters are similar question. Here, first of all, may I draw my lord's attention to Annexure 1 is a petition filed by a religious institution claiming to be the trustee, challenging a sale deed of 66. After 45 years, they challenged my possession and prayed for eviction in a Section 25 proceeding under the Orissa Hindu Religious Endowment Act. My first hurdle may I just fairly submit. There is a alternative forum of suit is there. But what happened here, my lord? I will come to that. Therefore, I am submitted from the beginning. That will be my hurdle because my friend may raise that question. Lordship, kindly turn to first the Annexure 1. Annexure 1, page 8. Page 8 is the petition which they have filed to evict me. May I just indicate paragraph 2.
Yes.
The claim was, I am an unauthorized occupant. Paragraph 2, that is the last part, second line, being unauthorized. That's if the word I emphasize. I am an unauthorized and collection there from being not utilized since slum. That was the allegation and the prayer was made to evict me. And Lordship, kindly turn to my written note in which I have annexed that amended portion. This unauthorized word has been inserted in the year 1981, my lord. I have annexed for my lord's ready reference. This word was not there in 66, my lord. They admit my alienation in 66, my lord. Your lordship, kindly turn to
this petition is under Section 25.
My lord, 25 to evict me. I came into possession by virtue of a sale deed of 25 March 1966, my lord. Who is they admit? What they say, since it is without any authority, therefore you are unauthorized. So my respectful submission before your lordship would be, this unauthorized word inserted in the year 1981 only. Here, my possession is from the year 1966. At best, I am a occupancy right under the Odisha Estate Abolition Act. because they claim they are the intermediary under the state. Therefore, the land should have been settled in their name. Because 18374, the estates are notified as vested to the state. Thereafter, law has also provided, I have also inserted, annexed that was also amended. Section 8 of the Odisha Estate Abolition Act. How their right has been extinguished in the meantime, but their application has been entertained and I have been directed for eviction. Lordship, kindly turn to the second gazette notification I have annexed.
So you are giving much emphasis on this, the word unauthorized.
My lord, I am coming to the second fault. Unauthorized inserted the two amendments. One in
According to you, a person can remain in unauthorized possession.
No, perhaps I am not clear to my lord.
Yes.
I'm sorry.
Could remain in unauthorized possession because that word unauthorized was not there in the statute.
I am not clear. In fact, that was not mentioned.
Yes.
My point was, if by any means I came into possession under the Odisha Estate Abolition Act, I am a occupancy right under the state, not under the intermediary. Intermediary lost its right by the amendment in Odisha Estate Abolition Act I have annexed, because it says they have to file application within 1 year of the amended provision claiming their right.
All right. This application was filed by whom?
My lord, there are two faults. My submission is two faults.
See, this application under section 25 was filed on whose behalf?
Filed by the religious institution claiming to be the trustee, person claiming to be the trustee.
Why are you bringing intermediary?
My lord, that link I could not establish. I am linking that. They have no right under to prosecute that, to proceed under section 25, because unless they are having the right of that land over that land, they cannot maintain the 25 proceeding, my lord. Am I clear, my lord?
Who does not have
the petitioner in the 25 proceeding?
Petitioner has no right.
No right, my lord. By virtue of this.
Right. Who has the right?
But it
is
settled it should have been settled in my name, because I am a occupancy tenant under the state since 1966, and by implication of law, my lord, in the year 78, they lost their right, having not filed the application under the OEA Act, my lord. That is my entire submission. Because
why are you bringing OEA Act?
Because OEA Act.
According to you, you are a vendee.
I am a vendee, man.
Your right will depend on the right of the vendor.
That is first part of my submission.
All right.
At best, my second alternative submission was, yes.
So according to you, you are authorized.
Yes.
Because of a sale deed in your favor.
In the year 66.
Executed in 1966 by someone.
Mine.
Your vendor.
Mine.
So you are authorized or unauthorized will depend on the right of your vendor. Let us close it.
Yes, that's right.
This is 1 plus 2 is equal to 3.
In that way, yes.
All right.
Yes.
So now, how do you bring the intermediary into controversy when this application was filed under section 25 of the OHRE Act?
My lord, now I got my lord's query.
Yes.
A person, why I bring OEA Act into the play? Because their right should have been established first before filing of the 25 application. Unless they are the owner of a property, they cannot maintain the eviction proceeding. Therefore,
the owners, this is DT's property.
My lord, that is the crux of the issue here. So DT's right has been extinguished by implication of 78 Act, my lord. That I have filed. 78.
Yes.
In the written note, I have annexed that. In the written note.
Let us see the Act. I don't know.
My lord. In the Act, in that book, it is at page. Section 8A3. After the 5th proviso, that has been amended. And it was amended in the year 1978, my lord.
Odisha. All right.
Odisha Estate Abolition.
What is there?
Odisha Estate Abolition Act. If your lordship.
Just referring to which section?
I am referring to section 8 dash capital A, 6th proviso, my lord. A2, thereafter 6th proviso. It was amended in 1978. In the bottom, it is reflected. Act 25 of 1978. That's it. 8 capital A.
Again, we are.
May I just get it? Well, just.
This is not as simple as that the court should
I will
entertain
establish
this writ petition.
I will establish my points.
No. Even if you convert the High Court into
not
the
at
court of a munsif,
My lord,
then-
not at all.
so
Not-
if you can maintain a suit, you file a suit.
My lord, my point
Had
is
it been a simple straight case of the court's interference, the matter would have been different. You can file a suit.
the order is apparently erroneous. Therefore, I am before my lord in the writ jurisdiction. On the ground, they have no locus standi to maintain that proceeding.
Challenge that.
My lord, in view of this amended provision, and they apply the amended provision and the OHRE Act, which was brought in 1981, and applied it to a transaction of 1966. Two point on law I'm submitting, and to that effect, one judgment of honorable
Sir,
apex court.
again, you are bringing this act.
My lord,
You are applying this act. And
two
this.
state act.
Please come to paragraph 1 of the petition under section 25.
Yes, my lord.
So what is there?
6.
No. The petition which has been filed and which is there at page 28.
I'm sorry, I'm not able to.
There is a petition filed.
Petition filed by
before the Commissioner Bhuvaneshwar.
My lord, at page 8.
Under section 24 of the OHRC Act.
25, my lord. Yes.
25 of the OHRC Act.
At page 8, that is
At
the
page
petition.
8. Who has filed it?
That petition was filed a person claiming to be the trustee of a religious institution.
So he is not a trustee according to you.
According to me,
Challenge that.
he lost his right to maintain
Challenge
this.
that.
That I have.
Not here, not in the High Court.
And my point is,
Sorry.
though I have indicated the point of law and it was discussed, may I just indicate the impugned order?
See, what have you done? You filed this writ petition in 2012. We are in 2024. Had you filed a suit, it would have been decided by now.
My lord, the difficulty would be, my lord, the difficulty would be, let's kindly have a glance to section 25. What it says. How I am not able to maintain the suit, that is section 25(3). Therefore, I am not able to maintain the suit. Therefore, the only remedy is before my lord.
No. Delay.
Page 25.
Delay.
Then the collector has to issue a requisition after the order of eviction. That has not yet been done till date. Your lordship kindly find section 25(3). It clearly stipulates section 3, lordship here. 25 subsection 3. Any person aggrieved by the action of the collector may institute a suit. And thereafter, 25(1), the last portion, the commissioner has to issue requisition to the collector and collector has to take action. Thereafter, my right remedy to file suit will arise. Therefore, now in the meantime, only the eviction order has been passed by the commissioner. Therefore, I am remediless. Now, every day they are threatening and will be ousted from the.
So, against the order of the commissioner, there is no remedy.
This is the remedy after the requisition issued by the collector.
So, he may issue, unless that requisition is issued, you are safe. Once that is issued, you can file a suit.
My lord, again, that will create problem for me.
May create a problem. But this 2012 writ petition should not remain pending here.
My lord, I'm not praying my lord to interfere with those factual aspects, only on the question of law. My submission would be They apply
So
the,
you want the question of law to be decided by this court for the civil court to decide your suit.
no, my lord, this
That
on law it
question
can
of
be
law,
decided.
Mr. Counsel, that question of law can be decided
Yeah.
in the second appeal also, if that is substantial.
But perhaps I'm not clear. to
That
my lord.
question.
The proceeding itself,
Mr. Das,
my lord,
that application under section 25 has been allowed because permission under section 19 had not been
not been
taken.
granted. That
So
was
was
the
section 19 in existence at that time?
section 19.
Don't tell
Yes,
offhand, just
yes,
check.
yes, it
Because
was.
I have the amended provision here.
Yes, it was there.
Then.
It was there. In 89, the rule, in 2012, the rule was amended. The
No,
rule
no.
was not prescribed. Therefore, this honorable
Section
court,
has also been amended, but to what
Correct.
extent that is not
this honorable
available
court
here.
prescribed the rule in by virtue of this honorable court judgment. In 2012 only they prescribed the rule. And there before it was not there. Now, my submission for lawsuit would be, unless that requisition is issued,
We will not record any of your submissions.
I'm remedialess, madam.
You may be remedialess because no action is being taken against you for eviction.
This is the order, my lord.
So this is the order.
Annexure 3.
The collector is yet to pass an order.
Annexure 3, my lord. Let's see, kind of. Annexure 3. Annexure 3 pays at page 13. This is the eviction order.
Yes, requisition be issued. Why has the requisition not been issued? Because of this writ application?
My lord. My lord. That's true. That's true. That's true.
The petitioner in the present writ application has put to challenge an order dated 6/3/2012 passed by the Commissioner of Endowment, Orissa, Bhubaneswar in OA number 7070 of 2011, passed under section 25 of the OHRE Act 1951. So, by the said order, the Commissioner of Endowments has ordered that the land in that a requisition be sent to the collector of the district for delivery of possession of the case land to the petitioner DT, to its managing trustee or the person in management. So stop. Land counsel appearing on behalf of the petitioner has raised many issues to contend that the person who filed the application under section 25 of the Act did not have the locus standi to make such application in view of the provisions under the Orissa States Abolition Act 1951.
Section 8, capital
We are
8.
not inclined to go into all such aspects in view of the clear provision under section 25 of the Act, which gives the petitioner, which provides a remedy to the petitioner in such matters and reads as under. So stop. Unfortunately, we have been informed that no order has been passed by the collector. under
It is
section-
unknown to me, my lord. My friend can say better.
Huh?
My friend can say better. It is not yet.
Counsel for the petitioner has submitted that
Not received.
that according to his instructions, the petitioner has not received any order passed in accordance with subsection 3 of section 25 of the subsection 2 of, where is that? Collector.
2, man.
No, 1.
1 and 2, both.
Any order or any order?
Subsection 1, last 3 lines.
In accordance with the provisions under section 25 of the Act.
Yes.
So stop. Till subsection 3 of the OHRE Act provides that if any person is aggrieved by action of the collective, he may institute a suit in the civil court to establish his rights. For stop in such view of the matter, thus writ application is dismissed as the petitioner has alternative remedy, equally efficacious. For stop, this writ petition is accordingly dismissed with the liberty to the petitioner to take recourse to appropriate provision of law. Yes.
All 3 matters are
All 3
similar.
matters.
I'm obliged.
Item 21.
My lord, my petition has been dismissed for non-prosecution. I have filed for condolence of delay. That was also dismissed 11/12/2023. Petition has gone to the apex court. The delay has been condemned. This my petition may be restored. Complete the order of the apex court.
So your petition should be restored.
Yes, ma'am.
So where is your application for restoration?
That has been dismissed by this court. Then I have gone to the Supreme Court. Supreme Court restored it. Orders
Restored it?
Supreme.
Give.
Copy of this.
Just please wait.
Yes.
Para 6 and 8.
6. Where is the other side? He had been asked to appear today by the Supreme Court. Not there. The bank, Andhra Bank.
And then I have also filed for amendment. Andhra Bank has changed to
Corporation Bank.
Union Bank.
Sorry, Union Bank.
I have also filed the petition for the amendment. Cause this.
Who is for the bank? Who is for the bank?
Nobody is appearing.
Someone is appearing. Then we will take up the matter tomorrow. There is an order passed by this court. So there is no representation on behalf of which bank?
Union Bank now changed to Union Bank, my lord. I have also filed the amendment petitions. I filed my amendment petition by MC number 2806 of 2029.
Issue notice. Issue notice. By 21. The limitation of restoration of a reputation.
Yes, ma'am.
Where is it?
Limitation also have.
So where is the law? If your reputation is dismissed, which clause, which article of the limitation petition, of the limitation act, provides for the period during which the restoration application is filed? Are we clear?
Yes.
So this is a writ proceeding, and if the writ proceeding stands dismissed for default, which what is the limitation? Where is the limitation prescribed?
It's so far as civil matters are concerned, 30 days limitation period. So for criminal matters, there is no limitation, but I think 30 days limitation prescribed under the High Court rules, not
High Court rules.
not under the Limitation Act.
All right. For writ petitions also. For writ petitions. All right, if it is there, it's all right. We'll examine. Yes. Issue notice. Huh?
Yes, correct. We are not pointing out that unless the amendment is allowed, to whom will we issue notice? So we are allowing the amendment, you file a consolidated cost title, and we are also issuing notice.
Only the cause list, my lord, instead of Andhra Bank, it will be.
So who will file that? So who will file that? We are asking you to file the. You already filed?
Yes, ma'am.
Where?
No, I have not filed.
Exactly, we are asking you to file that.
Once the amendment is allowed, I will file.
This is what we are doing.
Yes, ma'am.
Oh, he has filed. No, but we are not even in it. He has filed also. And then modification.
Sir N.K. Mahanti, learned counsel for the petitioner, brings to our notice the order passed by the Supreme Court in Civil Appeal number 7274 of 2024, arising out of SLP bracket C number 2175 of 2024. Order dated 9 July 2024. Wherein the Supreme Court has it has restored WPC number 4686 of 2023 and has also directed that the writ petition should be disposed of on merits expeditiously, preferably within 6 months after issuing a fresh notice to the respondents. Full stop. Mr. Mahanti, learned counsel for the petitioner, submits that in the meanwhile, Where is that IA?
Like,
Like F? Data operation reproduction है लिख लेना ना आपने IA 2806 of 2022. Mr. Gandhi and counsel for the petitioner submits that is your right. That Andhra Bank, the original opposite party in the case, has have you given the notification or just your averment?
The file is, it has not been heard.
Has merged with Union Bank with effect from 1/4/2021. For which he has filed this IA for substituting Union Bank and the zonal bank, Union Bank. Substituting the original opposite parties with the following opposite parties indicated in the schedule. Schedule ta please 1, 2, 3, 4 अच्छी extract कर देवे. Considering the submissions, the IA for what is this amendment or amendment of the cause title is allowed. The IA is disposed of. Mr. Mahanti undertakes to file the consolidated cause title by day after tomorrow. If the cause title by day after tomorrow, issue notice to the newly added opposite parties by registered post with AD / speed registered post / speed post with AD, returnable within 4 weeks. Requisites for which shall be filed within a week. List the case, 6 weeks about a date.
4th September.
4th September. All right. Please file requisites with that consolidated cause title. Mr. Mahanti, consolidated cause title you'll file for the court and you'll also file requisites with the consolidated cause title within a week for issue of notice to the opposite parties. Data out 6 4th September. All right.
Please show us that provision of the limitation for the restoration.
Item 22.
Your Lordship, I'm appearing on behalf of the petitioner. The learned senior is currently engaged in another matter, so I'm seeking an adjournment to some day post Tuesday, next Tuesday. So kindly.
Wednesday.
Indeed.
So making a mention on behalf of
Disengagement Pradhan.
Mr. Pradhan.
21.
22.
22.
22. Item number 22, Your Lordship.
What is your name, please?
Rahul Pradhan.
But you can tell them that we are a bit embarrassed because this is 2013
13 matter.
Indeed, Your Lordship. Your Lordship, currently the senior is engaged in a matter he's
Okay.
out of station at AFT Calcutta.
What is the order sheet? Last it was listed 2015. Public will the direction to the story matter because last listed 2015. So 1 week.
Your Lordship, any day after next Tuesday.
All right. Mr. Rahul Pradhan, Learned Counsel, appearing on behalf of Mr. Bisikesan Pradhan, Learned Counsel for the petitioner, prays for an adjournment. Prays for an adjournment after 30th 7/2024. Full stop. Considering the fact that the writ application is of the year 2013, we reluctantly allow the prayer for amendment allow the prayer for adjournment. List the case on 31/7/2024.
Much obliged, Your Lordship.
For all the members of the bar, that I am contemplating to list old matters once a week. I think on every Thursday, old matters shall be posted in all the courts, because old matters are pending and they are not being listed. So this is what I contemplate to do.
In some courts, they are listed also, old matters.
Old matters, yes. So now there's so many matters pending. We are taking up 2024 matters, but we have not like this. This is an example. 2013 matter was last taken up in 2015. And after 2015, that has not been listed. That was never listed. Therefore, old matters shall be listed on every Thursday in all the courts.
Right.
Item number 23.
Item 23, just to recollect now, this is a writ petition where I had challenged the cancellation of my lease. Your Lordship may kindly see the order dated 24/4/2024. 24/4. After complete hearing of the matter on merits, there was a suggestion that if the present market value is given, that Your Lordship may point out.
That hotel or something?
The hotel. 24/4/2024. Your Lordship may kindly see. Without entering into the controversies relating,
Please.
Controversy relating to failure on the part of the petitioner to establish a hotel on the land allotted by ITCO. Our Senate Council representing the petitioner has submitted the petitioner is ready to pay the benchmark value of the plot in question if ITCO agrees to revoke the cancellation. Accordingly, representation was made as per Your Lordship's direction, and they came back with a reply to before Your Lordship. Kindly see that. That is, Your Lordship sees affidavit filed on behalf of hospitals 2 and 3 in compliance with order dated 24/4. Affidavit filed by what? Manish Kuntia.
Yes.
Lordship got it? 114. Perhaps it is running page 114.
Yes, they're not giving that. They're in charge. So, which affidavit are you referring to, Mr. Mukherjee?
The affidavit filed on behalf of the opposite parties 2 and 3 in compliance to order dated 24/4/2024. Lordship got it? Oh, bless. Then kindly see page 6 of that affidavit. They have given the benchmark values. As per Your Lordship's direction, they have given one benchmark valuation there. Lordship kindly sees this benchmark valuation, District Khurda, Registration Office, Khandagiri, Village Thana, Chandrasekhar, Kisam Commercial, plot number 17. Lordship got it? And the commercial and the benchmark valuation and the next page is this much.
You are reading paragraph 6?
No, page 6 of that affidavit.
Okay.
That benchmark valuation which they have given. Annexure, page 6. Lordship got it? Benchmark valuation.
7.
Benchmark valuation, district so and so, plot number 17. Lordship got it?
Yes.
The plot number 17 they have given and the benchmark valuation they have given in the next page. Now, my limited submission here, you know, this plot number 17, they have committed an error. Because this is not the plot which is in dispute before Your Lordship. Your Lordship may kindly see page 21 of the writ petition, annexure 1, which is the plot property which was leased out. Page 21, annexure 1. Shall I place? With reference to your application, let so and so, let us so and so.
it was C by 4 measuring 2 acres, here and after photos, they must be corresponding to revenue plot number 69P in village Chandrasekhar. So our plot is 69P in village Chandrasekharpur, not plot number 17. Now, so therefore, to this affidavit which they filed, ITCO filed, I have given a reply. And I have given the benchmark valuation given by the sub-registrar himself. Your Lordship may kindly see that affidavit. Dated 30th of June. Reply affidavit filed by the petitioner. Page 6 of that affidavit. Got it. This, I'm to inform you, benchmark valuation, as valuation, so and so, of plot number 69P, Kisam Garwari, Chandrasekhar. This is the valuation which I have given right from the sub-registrar. And it relates to the plot which is in dispute before your Lordship. Not plot number 17, which is not in dispute. Now, this, it has given a benchmark valuation, 14 crores, some odd. Now, this case, this price is the price for sale of the land to the person. But we are concerned with the case of lease. As I was pointing out in Annexure 1, the plot is allotted on leasehold basis for a period of 90 years.
No.
So therefore, they have a set of guidelines for fixing this on the benchmark valuation. What is to be fixed? The lease.
No, this valuation of whatever has been done by the sub-registrar,
yes,
that is for the purpose of payment of stamp duty.
No, for sale.
That is the for sale. Like that is the minimum value. That is
that is, I think, the informed value, highest valuation as per Kisam.
No, highest.
I am to inform you at benchmark valuation stroke highest valuation as per Kisam, highest valuation as per plot number 1. Your Lordships had directed benchmark valuation. This is the benchmark valuation or the highest valuation as well.
So what is their basis?
But their basis.
I'll tell you. I'll just clarify my learned friend's permission. Your Lordship may see the reply which they have filed, which my learned friend has been referring to, paragraph 3.
Paragraph
3 of that at page 2.
Yes.
The disclosures made in the affidavit in question are all incorrect not based on records. In fact, the benchmark valuation disclosed by the opposite parties 2 and 3 in the affidavit in question, as would appear in page 4 of the affidavit, relates to plot number 17 of commercial Kisam. In fact, the petitioner's land in question, which has been allotted and for which the present writ petition has been filed, is in respect of plot number 69, Kisam Ghorobari, Moja Chandrasekharpur. So if it is a Ghorobari land, the valuation is 14 crores 70 lakhs. Ghorobari is homestead. He intends to use it for hotel, construction of hotel. This plot, incidentally, benchmark valuation, this plot in the benchmark index has been entered as Ghorobari. Now, he wants to utilize it for industrial, in the industrial zone, he wants to use it for commercial purpose. So what we have done is, we have taken the nearest commercial plots index, which is where the index is 22.4 crores, and that is what we have demanded.
This is unreasonable, and don't compel us to enter into such.
Yeah, my lord, my submission is this, my lord. He says further in the affidavit, he says that he is in paragraph 6 that he is ready to pay the benchmark value. In paragraph 6, he says,
yes,
1, 2, 3, 4, 5, 6 line. To reiterate, it may be submitted here. Petitioner is ready to pay the premium on the benchmark valuation at Annexure 17. So benchmark value of the plot is 14 crores 70 lakhs. We have demanded 22.4 crores. I leave it to your lordship. Your lordship may decide. I leave it to your lordship because and this is the logic for which we have demanded 22 crores is because he wants to use it for commercial purpose.
All right. But
So
just-
that is the only
sit
thing.
together, sit
I leave it
together.
at whatever your lordship.
Sit together, decide yourself, let the department.
Your lordship may close this matter.
Court should not. Particularly in financial matters, the court should not, unless.
Well, it's
In fact, my lord, with due respect, my lord, they have calculated. They have also calculated, because this is a lease. Because if it is a sale, your lordship knows sale is absolute. Lease is for a temporary period. Premium is fixed. So, and they have fixed that premium. I have given that document also. They have fixed it themselves, and they have a modality for calculating.
my learned friend is entering into an arena for which I will again have to go back to the merits to say that the lease has also already stand determined because 24 years.
No, that is not
24 years he has not utilized the land. Lease has already been determined.
Let us.
We just wanted to give him a chance. Let him.
Who heads the INCO?
Is headed by the chairman come managing director.
So ask your client to coach him.
Well, it's, I have.
We will take up the matter. We will take up the matter tomorrow again. And tomorrow.
Your lordship may take it up on Monday, because
Monday is the first case.
Monday is the first case. Yes.
On Monday is the first case. In the meanwhile, you please resolve it.
Yes, my lord. This is the only issue.
This is in the interest of
benchmark value is.
See, this is in the interest of the IDCO. This is in the interest of the petitioner.
Absolutely, my lord. This matter should be closed now and here. It's been
that is also
hanging
that,
fire
that
for
is
quite
also
some
there.
time.
They want to promote.
If you both of you compel the court to decide, the court will have no other option but to decide. All right. Everything, every aspect.
We will certainly, definitely not. What your lordship is telling is the correct.
Therefore,
because they themselves have decided they have fixed the price.
Just slightly above and slightly below, like in between.
But I would request my learned friend to go use his good offices.
Yes,
and
he will surely do it.
I'll talk to them.
They have decided. They have
in
come
view
to a
of,
conclusion.
in view of the rival stance taken on behalf of the petitioner and the IDCO in the affidavit filed on behalf of the IDCO and in their respective affidavit / a reply affidavit, we adjourn the matter to Monday, when it will be taken up as the first case. Stop. In the meanwhile, the court expects the managing director IDCO and other stakeholders to resolve the issue amicably.
Okay, much okay.
Is it MD or CMD?
Your lordship has said managing director because sometimes there are two different persons, but it's the managing director who is competent to take a decision.
Interim order may continue.
Interim order shall continue in the case. Resolve it, Mr. Both of you.
I think it can be resolved. Some relaxation.
Solve it.
Item number 25.
Wait, please, my lords. Matter of blacklisting, my lords, without adequate notice. Lordship may kindly turn to page 65.
Where is the order?
65 is the order. This is second round litigation, my lords, second journey to your lordships. What, my lords? Originally, they blacklisted me on 9/2/2021. This is the order, Annexure 11, page 65. With reference to the above cited subject and letter, I am to inform you that your firm or agency is hereby declared as blacklisted, and your firm will not be allowed to participate in any tender in Contempt district for the coming 3 years in future. Now, my lords, against this order, I come to this honorable court, my lords, page 75. Order dated 5/4/2021. My lords, the Honorable Single Judge heard and disposed of the matter by a specific direction, my lords. Considering the submission, page para 2. Considering the submissions made by the parties, this writ petition stands disposed of, with a direction to the opposite parties to consider the grievance of a petition at the instance of the petitioner wide Annexure 11 and take a lawful decision in the matter, taking into consideration the grounds stated in this writ petition and documents appended thereto, and also the decision in the case of UMC Technologies Private Limited versus Food Corporation of India, reported in AI 2021 Supreme Court, page 166. The entire exercise shall be completed, giving opportunity of hearing to the petitioner within a period of 10 weeks. From this date.
Then what happened finally?
Then, my lords, finally they heard me, and my lords, they pass a final order, Annexure 15. That's at page, my lords, 18, 19/7/2021. I am aggrieved, my lords, by the last part, page 83. It starts, my lords, my lords, to put the facts in perspective, my lords, it starts at page 82. And whereas, with regards to the order of the Honorable Court on 5/4/2021 arising out of WPC number 11313, the representation dated 19/6/2021 filed by the present petition by the above named petitioner was examined with reference to all documentary evidence and found no merit for consideration, hence rejected. However, considering the representation of the agency, the word of blacklisting is hereby withdrawn. Now, this word of blacklisting, they remove the term expression. The said agency shall not participate for providing different category of manpower on out-of-source basis for the coming 3 years in Kandhamala district. The security deposit is hereby forfeited. Now, because the UMC Technologies judgment, my lords, paragraph 21 of the UMC Technologies, your lordship will.
No, but those 3 years are over.
My lord, this is 3 years is over. I am only on the stigma. Because the 3 years is over and the stigma continues. Unless this stigma is called, that is against the, my lords, grain of the judgment. Paragraph 21, specific direction of this court was you considered in light of UMC Technologies. UMC Technologies, my lord, says, I just short.
Not required. I can understand. See, blacklisting
If
is
you want to blacklist
no
me,
one shall be awarded to.
right from the show cause stage that you want me to blacklist me and give me an opportunity to meet that. So they did not, they gave all kinds of allegations, but there was no indication, no whisper in any of the show causes that you want to eventually you will blacklist me.
So we will record that will not be treated to be stigma.
Grateful. That will take care of. That will take.
The petitioner in the presented application has put to challenge an office order dated 19/7/2021 passed by the Office of the Collector and District Magistrate Kandahar, Pulbani, Kandhamar, Pulbani, operative portion of which reads thus. Page 82, 83, last paragraph. So stop. Manifestly, the operation of the said order has become ineffective with the efflux of
time,
that is, period of 3 years. So stop. Learned senior counsel appearing on behalf of the petitioner has, however, submitted that on the one hand, the collector decided to withdraw the order of blacklisting. Where is that?
Man, that's at page 83. Second line. However, considering the representation of the agency,
withdraw the order of the blacklisting, the agency was not allowed to participate for providing different category of manpower on outsourcing business for 3 years, which has the same effect of blacklisting. First off, he contends that this stigma shall continue with the petitioners, plus petitioner is a company
It's a
for may continue for all
partnership.
times to come.
It's partnership.
Stop. Next, considering the facts and circumstances and the nature of the impugned order which has been passed, we dispose of the present writ application with an observation that no observation made in the order dated 17/7/2000, impugned order dated 17/7, 19/7, 19/7/2021 shall be treated as stigma for any work for which the petitioner may participate after 19/7/2021.
Great.
With your lordship permission, lordship kindly permit me. Item 27 notice has to go. Government has filed writ appeals. In one case, I have appeared.
7 has not been taken up.
No, 27. Next item.
Next item, yes. What is this?
That writ appeal, actually, there are 4 other writ appeals government has filed. They are independent cases relating to same subject matter. But notice has not gone. Some other lawyer may appear in those cases.
So we will hear in the next time.
Right.
In the second. Or tomorrow. Tomorrow.
I'll already play item number
Date
6.
shall be fixed. Which
Hello.
date?
31st, I was saying.
31st? Please.
31st will come next to the.
My lord, item number 60. Item number 60.
Interim order shall continue.
Sub item also same.
My lord, item number 60, the contempt petition. So cause was filed by the state. I have filed objection today.
60.
60.
Let us try
I have
to
filed objection today. Let the matter come tomorrow.
let it reach. Let us reach.
I'm
there.
not available.
You are not available.
But that is tomorrow.
Do you have friends in the bar? Huh?
Yes, yes.
Any friendship?
Yes.
Huh?
So,
Ask someone to be.
yes.
Let it be called.
No, your lordship, it's item 33 has been initiated.
Oh,
So the sub item, I am concerned with the sub item.
all right. Let it be called. All right.
That limitation matter, lordship wanted to know that CMAPL
Yes,
limitation. It's chapter 8, rule 30 of that chapter 8 read with rule 2, Millers. Rule 30 of chapter 8 deals with readmission of matters which have been dismissed or default.
Just a minute. Just. Chapter 8 rule.
Rule 30, Millers.
Chapter
30.
30.
It deals with matters which have been dismissed for default for the restoration. But rule 2 minutes of that said chapter deals with limitation. It says that 30 days, any order within 30 days has to be filed by before the Honorable Court. Minutes. So that's why we are filing it at the limitation of 30 days. Minutes.
This is what I was thinking.
Yes, there are no limitation prescribed.
No, rule 2 limitation is prescribed law. 30 says that, not says to, rule 2 deals with limited, and 30 days, any order application is filed within 30 days before the National Court.
Rule 2.
Yes, no.
Rule 2.
Same law, so chapter 8.
This is regarding writ appeal.
Writ appeal order, but following that rule only means within 30 days.
Not following. If it applies to writ appeal, how can it follow?
No, that is the SRs are doing that. That is why
There is a provision 30 days, but
and rightly so, we have noticed reference of a decision which says that writ petition dismissed for non-prosecution, Article 122.
Not applicable.
Will not be applicable.
Yes.
Article 122.
So there should not be any limitation, but
There should not be any limitation.
Right, Milord.
So restoration, not a reasonable period, the court will consider whether
Right,
it is. But limitation will not apply.
Also demand the order of the
Give us an opportunity, we will decide it.
And interestingly, so far criminal matters which are dismissed by default, no limitation is pointed out by the stamp reporters. But in matter of civil matters, they say it should be 30 days.
It cannot be writ proceedings.
But 137 of the Limitation Act, it says when there is where no other provision is provided, then it is
not apply to 226.
Yes,
226 is entirely different.
3 years.
3 years. Where no application has been provided, where there no limitation has been provided under any statute.
See, Limitation Act cannot control Constitution.
Yes.
As simple as that.
Yes.
You cannot accommodate me for the day in item 35.
Let the matter be called. Ask someone to be here when the matter is called.
So he's appearing because nobody appeared. She was saying that she'll file a counter. That's why I'm saying,
Please ask someone. Just ask someone to be here. We'll accommodate. Just give us a date on which both of you agree. Yes. जरा सा एक काउंटर करेक्शन
हाँ इधर
Yes, sir, please.
Item 24.
Last occasion, my knowledge senior attended for the petition that sheet.
For my content, begin Milord, that I had submitted on that day. That for encapsulating your lordship's memory, only I am something. That
No, you are appearing for whom?
I am appearing for the petition.
And you?
I am from the
High
High Court.
Come this side. You please come this side.
Because
Yes.
Order passed under the Annals of 23. At page 140. Asked by the sub-collector, if the subject matter of challenge before the lordship.
Yes.
That the sole question involved in this petition that if applications were invited, tender notice was issued for auction of these items, and his petitioner and the opposite parties, now 5 was the participant for such auction. And he declared as the highest bidder in respect of 2 sides.
He means who? He means who?
Highest bidder in respect of
Who?
You are the opposite part number 5. Opposite part number 5 was declared as the highest bidder in respect of 2 sides.
that is Sabara Sandbag and Sangagua Sandbag. I have given it red chart here also. At serial number 2 and 3. By 14, the additional charge, rupees 186 and another is 159, 169. So you are declared as highest bidder in respect of two sellers, but he has utilized one solvency certificate in respect of those two sellers of rupees 30 lakhs. Though he was required to pay of solvency of rupees 67 lakhs 79,970. And while he was declared the highest bidder in respect of two sellers, the Tahsildar allowed him to operate one seller by accepting the bid in respect of Sangha, in respect of Sabara Sangha. That was challenged by the petitioner by saying that since he has been declared the highest bidder in respect of two sellers and has given one solvency, so therefore Tahsildar has no choice to give one seller to the impact number 5, and
He's given one solvency which doesn't cover both.
Does not cover. One solvency does not cover both. So therefore you have no choice to give one unless he surrender. Unless he surrender one, you have no choice to give one. So it will lead to a tender fixing. So therefore, that he filed the objection and that was challenged before the, and his bid was cancelled by the Tahsildar, and that was challenged in an appeal without implicating the petitioner party, though he is the second highest bidder. So therefore, he was invited to match the price, and accordingly matched the price, and he was selected as the highest bidder. And in respect of that Sabara Sandbag, he was invited to execute the lease. The mining clearance and other things, other formalities he has completed. At that time, he filed a appeal. Opposite party number 5 filed a appeal before the sub-collector. Sub-collector set aside that. That was challenged before the sub-collector because
Sub-collector set aside without hearing you.
Without.
By the time you had been granted. By the time had you been granted the lease?
Yes, yes.
Okay.
I was granted. And that was challenged before this honorable court. This honorable court remanded the matter for fresh hearing by giving opportunity to the petitioner. Thereafter, this order was passed under the answer 23 of Constitution. The main challenge was that since he had given one solvency and he cannot be allowed to operate one seller without surrendering one before the authority, and the competent authority has no choice to give one seller. That is the main challenge in the appeal, and the appellate authority of Procedural come to page 134 of the good order.
144, the impugn order or the writ appeal?
Appellate order. Annexure 20. That 120 at page 134. Yes. That is the last part of the first paragraph there was done. Yes. On perusal of the advertisement, what he has observed that on perusal of the advertisement, it is seen that there is no condition to file separate solvency certificates in submitting bids for different seller source by a single applicant. Thus, the plea of the respondent number 2 to disqualify the appellant on the ground of furnishing one solvency certificate for two Cyrus source is hereby rejected.
Yes.
Now, this is the, in substance, this is the finding of the appellate authority, and that is challenged before your lordship. And during hearing of this petition, this honorable court, in an order dated 21/6/2021.
When you were granted the lease, you asked to match the price of.
Yes, Lord. I matched the price, and according to the mining plan was approved. Thereafter, the environment clearance was given in my favor. And when I was about to operate the outsider, at that time the appeal order was there, or appeal order there. I challenged that order before this honorable court. This honorable court remanded the matter for fresh hearing, and the appellate authority rejected my allowed the appeal by passing this order. This is the finding.
Annexure 23. Annexure 23.
Thereafter, in course of hearing, this matter was heard in several benches before this honorable court. And during the hearing on the, your lordship can see on the order dated 21/6/2021.
Yes.
This honorable court, deliberating the issue on paragraph 5, your lordship can see the order.
Yes. Which page?
That the order dated 21/6/2021, your lordship.
Yes.
Order number 3. Your lordship got it. Order number.
Order number 3. Yes.
That's paragraph 5 of the order. The court directs opposite part number 1 to 5 to inform the court what the correct factual position is, and in particular whether the opposite part number 5 has in fact given up one of the silence, and if so, which one. Further, they will confirm if the calculation of the amounts for which the solvency certificate had to be furnished as set out in paragraph 10 of the petition is correct or not. But two things this honorable court has made two queries. One is whether he has surrendered one side of it, though he was two sides were finalized, and the calculation which has been given about the solvency in paragraph 10 of the petition, that is correct or not. But in pursuance to that order below, one affidavit was filed before this honorable court by the government. Then also can you see that counter affidavit at page 152.
What for you have referred to this order? Order number 3?
I am referring to this order because the rule says that the application can be invited for.
No, how, whether in compliance with this rule, order 21/6/2021,
Yes.
something was done by them.
The affidavit was filed by the government.
This information.
that was given to the government. The direction was given to the government to file the affidavit. Whether he has surrendered one of the side or.
Yes. So what is your stand on this, please? What is your stand on this paragraph 3 of the order number 3?
In fact, Lordship, I have in my regender, I have given detail by giving the figure also, Lordship.
No figure.
Lordship.
You told the court
Lordship.
that you have given up
Lordship,
one of the above sans serifs.
Lordship,
So which serif you had given up?
Lordship, that is Sana Gagua. The two Sweras, Lordship, one is Sana Gagua, other is
So Sana Gagua you have given up.
given up, Lordship.
Sana Gagua he has given up.
Lordship.
Had you given anything on writing?
Lordship, writing, Lordship.
Given Sabra.
I have given up Sana Gagua. Savara is Lordship, is now written question Lordship Savara. That is operating, that is in my favor.
All right. So where is that Sana Gagua sand query giving up?
Lordship, just I'm showing.
Not in your bag. It should be in the brief.
Brief, Lordship. In brief, no, Lordship. Brief. I'm showing Lordship. That is page, Lordship. Lordship, page 163, Lordship, can you see? It is available states counter, Lordship. That is one page 63, annexure C by 3.
Page 63.
163, Lordship.
163.
163.
Annexure C by 3. So here you are, I mean, in so many words, you have not withdrawn. You are saying that you are free to reject.
Lordship, that is available under the statute. Statute says, Lordship, if somebody declares highest bidder, then 15 days will be granted to him to convey his acceptance. That's why their Lordship wrote me a letter for acceptance. That is my reply. So I have, Lordship, I have given off, Lordship. Lordship, page 162 is their communication. In reply to 162, this is my letter, Lordship.
No, then you made a false statement before this court on 21/6/2021.
Lordship.
On 21/6/2021, you
Lordship.
made a false statement before this court that you had given up one of the above sans serifs.
21/6, Lordship. That is 21/6, 22/1, Lordship. It is.
No, order number 3 is dated 21/6/2021.
This is letter of 21/2020, Lordship.
Therefore, we are saying that letter is of 21/8/2020.
20, Lordship. 20, Lordship.
20.
20. This letter
Oh.
was 20.
All
At the
right.
relevant time, Lordship, immediately after completion of auction procedure, this is communication, Lordship, in consonance with the rules. So rule says, Lordship, if after declaration of highest bidder, authority will communicate me to highest bidder to accept the, Lordship, to acceptance of the bid, and 15 days time is there to convey my acceptance. In reply to that, Lord, this is my letter. I have, Lordship, said no, I can't operate.
Which other letter?
162 their communication, my reply 163 page, Lordship.
Letter, format, thereafter next page he has replied.
Yes.
Mr. Lorry,
Lordship,
page 162
Lordship,
is regarding acceptance of Sabara sandbed query.
Lordship.
And you have given a reply regarding the other one.
No, Lordship, in fact, Lordship, page 161 and 62, both are there, Lordship.
Lordship,
No,
I see
you-
161.
161.
You pointed to 162. That's
116, sorry, 161, Lordship.
Okay.
There. 161 is there. Lordship. Two intimations are there, Lordship. 161 in respect of that Sanagagua. Sorry, Lordship, extremely sorry.
161 is different context.
One 61, you are asked to give the solvency certificate.
Lordship. That is the Lordship. That is
So
the
that you said that you can't.
Lordship. I can't, Lordship. But I have an alternative argument, Lordship, that was not required. But due to my capacity, I denied, Lordship, not to accept the second, Lordship.
Yes. Anything else?
As far as that two letters are concerned. But people going to that letter, you can see the affidavit filed by the government. In pursuance to your lordship's order, the two orders were passed. And one is at 21/6/2021, and another order taken on 5/8/2021. In that order, this court has specifically specified the query by saying that whether OP number 5 had in fact given up one of the transider, and if so, which one? And OP number 1 to 4 will confirm if the calculation of the amount for which the solvency certificate had to be furnished as set out in paragraph 9 of the writ application is correct. That is, the lordship can see the subsequent order, that is 5/8/2021. 5/8/2021. In pursuance to the first order, the affidavit was filed, the counter affidavit was filed. The lordship can see at page 158. At page 158. The additional affidavit dated 2021. By that date, no surrender certificate, the surrender letter was there.
Which date?
That the lordship can see that affidavit of the government. The sub-collector filed the affidavit in this court. It is an admitted fact that the opposite partner of 5 had never withdrawn his bid, either in respect of Sabara Sand Quarry or Sangagua Sand Quarry, before opening of the bid, that is 9/1/2020.
So 9/1/2020, he had not withdrawn. Where is it is not his case.
That on the date of opening of the bid, he has to withdraw the one sand quarry and to finalize the other in his favor. On that date, he has to, that is the relevant date. He has to give that surrender.
All right, he committed that wrong.
Yes,
what is the consequence?
That the consequence is that entire 2 bids will be rejected.
Where is that?
That is because your lordship can see the rule.
Which rule?
The lordship can see that. But the scheme of the rule under the rule 27.
Yes.
The first is that area of the quarry shall be delineated and notification inviting applications for grant of quarry leases to auction shall be published in 2 daily newspapers, at least one of which shall be state level and other having wide publicity in the area.
No, where is the consequence that
Your lordship can see the subject to other provisions. Sub-rule 4. Sub-rule 4. Rule 27, sub-rule 4.
So sub-rule 4 cannot be applied.
That is subject to other provisions of the rule
Mr. This is of 2023. Where is what was the provision then?
The provision was then at 2020, this rule was applicable.
Sir, please come to your book.
Yes.
Is it old book or new book?
16 will apply. Conception rule 2016 rule. 2016.
2016 rule.
Yes.
Ah.
Two 2016 rules of
This is 2020. Yes. Yes.
Subject to other provisions of these rules for settlement of query leaves, the intending applicant may apply to the competent authority in a skill power for grant of query leave for such area or area in Form M in duplicate, accompanied by the following documents and particularly namely credit challan showing deposit of 1,000 rupees.
No, just let us understand.
4 years precedence. Roman codes. A solvency certificate or bank guarantee held for a period of 18 months for an amount not less than the amount of additional charge offered, and the royalty payable for the minimum granted quantity for 1 whole year and a list of immovable property from the revenue authorities. So the entire scheme of the rule is that you have to submit the solvency certificate on each application. Each application, you have to give the solvency according to the rule provided.
Yes.
First, you have to give the 36 lakhs sum odd, that is the Savara Sandpuri, and so far as the Sangagwa Sandpuri is concerned, he has to give the 32 lakhs separately, 2 solvency.
Since he had given one, they gave him the option.
Even one.
Yes.
Even one in both the Sandpuri, and he was declared as the highest bidder on the basis of the additional charge he has quoted. And when the bid was opened below, at that time, the very moment he has to surrender, if he has been selected for 2, then he has to give the letter on the very date that I am giving.
Where is that?
That is the
No, that is what he did. He did that on the very next day
not on
22nd. 22nd, he's
when the intimation was given to him under Rule 27.
Right.
Rule 27, sub Rule 7. What is the requirement? If you have been selected, you have to give the reply that this Rule 24/7 provides that within 15 days of such intimation, that is, intimation is to be given under Rule 27(6). The selected bidder shall be intimated by the competent authority within 7 days in Form F about the selection and terms and conditions of the lease. He has to give in the intimation about the execution of the lease. What is the requirement for execution of the lease? That after being selected and Form M was issued to him, the intimation is to be given to him. This is the requirement for execution of the lease. So you have to comply under Rule 27, sub Rule 7. It is not a requirement for surrendering of the one of the people. You have to, when it was declared as elected in respect of 2. So therefore, 2 sides, if there is a deficiency in solvency, then both the sides has to be rejected. If you are not surrendered then and there, you cannot wait till the intimation is given to him for execution of it. That is my submission before your lordship. So therefore, this court being conscious of that provision, this court wanted whether you have surrendered or there and there. And what is the requirement of the solvency which has been calculated, that is correct. And there is a recent judgment of the Honorable Supreme Court also, Miller. You cannot rectify the solvency. That solvency has to be given on the very date of application. It is a defective application. Both the applications are defective. One cannot consider in your favor. And after he being selected and after he being, the letter was issued that he has been selected for Sabra Santori. And you give this intimation was given for execution of the lease. Thereafter, this letter was given. So therefore, that letter cannot rectify his mistake which he has committed at on the date of application of the lease. And therefore, this honorable court passed the order, and the government clarified by its affidavit to recipients at page 150.
Yes.
So far as the application filed by him, from the very inception, application is different.
All right, we understood.
So that was you also can see the affidavit, government affidavit. The government has clarified by saying that it is an admitted fact that the opposite party on side has never withdrawn the bid either in respect of Sabra Sandpuri or Sandagua Sandpuri before opening of the bid on 9/1/2020 or after opening of the bid. The date of relevant date is the opening of the bid. He then Councillor Bonai, without rejecting both the bids of opposite party number 5 due to deficiency of solvency on 9/1/2020, had opened both the bids of the opposite party number 5. In both the bids, the opposite party number 5 was the highest bidder. And thereafter, at page 159, the last part.
Yes. What is solvency certificate?
That the solvency certificate is the financial viability of that person to operate the soil.
That has now been substituted with bank guarantee.
Bank guarantee.
That is solvency certificate.
And that not solvency or bank guarantee.
Rule 27(4).
No, solvency or bank.
Already recently, that has been amended.
See,
Or
solvency, there must be something.
My lord. That is the ordinance, my lord. Financial capability.
Financial capability, there must be some clarity.
My lord.
That if you have this much of capacity,
My lord. Then you can participate.
Treated to be solvent for the purpose of particular thing.
My lord, my lord.
So this, see, like, all right. So we can read this solvency certificate for an amount not less than amount of additional charge offered.
My lord.
Solvency certificate is also to that effect.
Additional charge offered plus royalty.
Plus royalty.
Yeah, that is calculated. We have given the calculation that paragraph 10 of the page 10 of the.
See, like there are 10 Sairats.
Man.
And he gives solvency certificate, one, for all of the 10, to claim that I had complied with this. This is not permissible.
He gives value.
Value within the amount offered, my lord.
Different. Huh?
Value within the amount of the offered. Because, my lord, the additional charge is minimum additional charge is fixed.
All right, let him conclude.
My.
Yes.
Now
the calculation we have given at page 10 of the DP. That is the solvency for each side. And he has to give total 67 lakhs sum at the solvency. Either you have to give one solvency for 32 lakhs 92,152 in respect of one Sandpuri, and the second Sandpuri you have to give 34 lakhs 87. You have to show your transparency that I am solvent to operate both the account, both the sides. But he has given only 40 lakhs and utilized both in both the sides.
No, but both the processes are separate.
Processes are separate.
It is not that the things are being conducted jointly.
No, not that.
All right.
Separate application,
Both the
separate documents.
separate application, separate solvency certificate.
solvency had given with which application?
that both the applications one.
The same one.
And both the sides, once he has declared as successfully in both the bids. So therefore, he has to furnish 67 lakh summers because he is qualified to operate this. Now, that is the objective of the rule. In
All right.
that, so therefore,
So where is the notice?
that the notice was given to the that Mr. was. Page 31.
Page 31.
Page 31 of the deal, I have given the translated. Page 31 and in vernacular it is page 30. I read it.
We can't read. Both. First page we can read, but
With reference to the subject cited above, I am to say that the number of siders of minor minerals of this tahsil will be settled on round-term lease basis for a period of 5 years by inviting bid through seal tender for which a soft copy of the advertisement for lease of the cider sold under this office duly signed by the undersigned is sent here to first send in Sundargarh official website for information of all concerned. Then below,
Then pages 32 to 36 are all black.
32 on vernacular.
No vernacular, nothing can be seen.
yes.
Then your lordship can come to page annexure 3.
Yeah, that is a correspondence.
What is the quantity of operation that has been given in respect of each cider? The Baltola, that is the 3 cider.
But that is your only submission.
That
That is your only submission that the solvency certificate ought to have been given in respect of both the queries separately. Or if jointly the amount, the corresponding amount.
absolutely.
This is your submission.
Yes.
Nothing more?
Nothing more. And once it is not submitted, both the applications are.
All right.
That is my submission and the one judgment of this. I'm only placing one paragraph.
No, but what is that judgment?
That at page 1117.
Yanti.
The last paragraph. That on perusal of the aforesaid rules, it appears that an application for query lease shall be made to the competent authority in Form J in triplicate and shall be accompanied with the documents as mentioned in clause I to clause 1 to 11. If the documents as enumerated in clause 1 to 11 of Rule 26(1), the parameter provision in 2004 are not appended to in prescribed Form J, then it can be construed that application so submitted for grant of query lease is defective, incomplete. The same could not have been accepted, considered by the authority. The cardinal principle of statutory interpretation is that in the language of the rule, this is not your lordship know this principle.
Why are you referring to this decision?
That I am referring to this, my lord. If there is anything slightest defect, my lord, then it will not be considered.
That's all.
And the second affidavit filed by the government in pursuance to your lordship's order, not second order.
Yes.
The government has filed the affidavit in saying well. That at 159, it may be noted that the opposite part number 5 has never withdrawn the bid either in respect of Sabra Sanctuary or Sangagua Sanctuary before opening of the bid.
That we have
that is there.
already. All right.
And so far as the calculation is concerned, they have clarified in their counter that whatever calculation is given in paragraph 10 of the petition, that is correct. So therefore, the under registry. That is my concern.
Yes.
Ma'am. Lordship, the opposite party, both the petitioner and opposite party number 5, my lord, participated in 2 Soirat, my lord. One is Sangagua and is Savera. Whereas the opposite party number 5 became the successful bidder in both the Soirat, my lord. And he has given one solvency certificate of 40 lakhs. And if his offer will be calculated and taken into consideration, the total amount Soirat would have been 67 lakhs more. He has given 40 lakhs.
More total.
Total, man. Total in both
Yes,
both this should be 67 lakhs, whereas he has given a 40 lakhs. Lordship, can you see page 100?
No, but what is
160.
your stand?
Mile.
There is specific submission which has
Mile.
been made that same solvency certificate ought not to have been applied for both the queries.
Mile.
So what is your stand on this?
My stand is that, my lord, he has to give in, even if he has given a single, my lord, he has to give in the minimum amount 67 lakhs more than minimum, because he has offered the amount 67 lakhs in both the Sandkori, and he became successful in both the Soirat, my lord. When he became successful, so he has to give the total amount 67 lakhs. What Tahsildar committed a mistake, my lord. Lordship, can page 161, my lord. Tahsildar on bid was open on 9/1. Tahsildar 16/1/2020 wrote a letter to the opposite party 5 to give the balance solvency, which is not permissible. Tahsildar has, and on the same day, Tahsildar committed a mistake. So moto granted Form F in favor of Sabara because he has never withdrawn. And on 163, 22 and 2022, he refused to give that the balance. I will not give. So by that time, the Tahsil has already settled one Soirat, that the Sabara.
So the one which was settled with him, he refused to give for that.
My lord.
No, he settled and asked for the.
No, my lord.
solvency, I
Page,
think.
no, my lord. Lordship, can you see 161 for a moment?
Page 161.
161. What the Tahsildar committed a mistake, my lord. This is to inform.
So
Lordship,
you are in principle supporting the case of the petitioner.
My lord.
Yes, one can do that.
My lord.
You are state council, you are
We have given the affidavit pursuant to Lordship direction
you have to take
dated 5/8/2021 that both the bids of the opposite party should have been rejected because due to fault of the Tahsildar. What Tahsildar did, my lord? He has to withdraw one bid before opening. He has never drawn. He has participated for the amount and he became successful in both the Soirat. So there is the less amount of the solvency. So Tahsildar, what he did, my lord, without withdrawing of the one petition, he requested to give the balance. So there is no question for submitting the balance solvency certificate after opening of the bid, my lord. Then the auction will be futile, my lord. Then on the same day, 16/1 granted an Form F in favor of the opposite partner for Savara. After receipt of 16/1, he wrote a letter on 22 after 6 days that I will not give the balance. That is the mistake.
all right. Yes. Yes.
Lordship. Lordship is rightly pointed out regarding the solvency certificate and the nature of participation, Lordship, in this tender, whether I have participated in consonance with rules or beyond the action procedures I have participated and I have committed by flouting any of the conditions of the contract, Lordship. But that much, let me clarify, Lordship, perhaps proper facts have not been placed before Lordship. In fact, there was an action notice in 2019 that the 3 Soiras will be put to action. By the next date, Lordship, they come up with the corrigendum that these are the nature of 3 Soiras, Lordship. And Lordship, page 36, Lordship, kindly see that they have given the figures. Lordship, page 36, it gives the minimum additional charges per, page 36, Lordship, kindly see. Because these conditions, Lordship, as per the 27 rules of 27 of the OMMC 2016, Lordship. Lordship, the last 2 columns I'm reading, Lordship, minimum additional charges per cubic meter and minimum guaranteed quantity per year these two requirements under the rules, Lordship. And as per the procedure of Rule 27, I have to participate in the tender procedure in obtaining certain documents which has been laid down under Rule 27, 4 of the rules, Lordship. So, Lordship, for a moment, where is the confusion? I want to clarify, Lordship. There is little confusion. The officers have perhaps that misread. That's why this entire confusion is come to play. Lordship, kindly come to Rule 27. Sorry, once again, I'm, Lordship, giving pen, Lordship, to again bring your Lordship's attention to Rule 27.
Yes.
Lord, 27, 1 speaks of, Lordship, the area of the query lease shall be delineated and notification invited applications for grant of query leases through auction shall be published in 2 daily newspapers, at least one of which shall be state level and other having wide publicity in the area where the lease is located, and such notification shall be published at least 15 days before the intended date of inviting applications and shall contain the date of time within which applications shall be received. It is regards to wide publicity. Then 2 is very important for me, Lordship. The notice invitation applications for grant of query lease shall be issued by the competent authority and shall be specified the minimum guaranteed quantity of the minor mineral to be extracted in year by the applicant and the minimum amount additional charge payable for the same as determined under Rule 14. That is the sub-rule 15. Wrongly, they have, that's sub-rule 15. In fact, rule says, Lordship, can come to 15. Sub-rule 15. That, Lordship.
According to you, this is wrongly mentioned as
14, Lordship. That is 15 year Lordship. That appears on the rules itself, Lordship. In all books, it is 14. In fact, 14, 15, Lordship. State, I'm coming to 15, Lordship. 15, Lordship got it 15. The minimum amount of additional charge to be quoted shall be such as competent authority in consultation with the controlling authority decide the specifying the notice inviting application for grant of query lease. So there is a determination by the competent authority in consultation with the controlling authority. Sub-rule 15, Lordship. Sub-rule 15.
All right.
Sub-rule 15. Again, I'm reading, Lordship. The minimum amount additional charge to be quoted shall be such as competent authority in consultation with the controlling authority decide and specify.
No, but why are you referring to this rule?
This is the entire confusion starts from here, Lordship.
No,
Lordship.
The confusion is in relation to 4.4.
Yes, I'll come to that. The entire confusion because the figure which has been shown by bringing the 67 lakhs, that is a wrong figure, Lordship. They have miscalculated this. Even if my 40 lakhs qualifies both the tenders, Lordship, that I'll only satisfy, Lordship. That figure I've given my regional, Lordship. So, Lordship, kindly, as per 27.2, itself appears there is a offer by the competent authority. What should be the minimum additional amount charged quoted by in the tender call notice? Then, Lordship, kindly come to Lordship 4. The entire confusion, Lordship, comes here, Lordship. Lordship 4. Subject to other provisions, Lordship, these rules of her settlement of the query lease, the intending applicant may apply to the competent authority in a sealed cover for grant of query lease for such area or areas, Lordship, areas in Form M in triplicate accompanied by the following documents in particulars, namely. So there is no bar in participating number of bids, Lordship, if they are coming up with differences. Area and areas, I can participate. Then, Lordship, kindly come to 4. State, I'm coming to 4, Lordship. That is important for this case. A solvency certificate of bank guarantee valid for a period of 18 months for an amount not less than the amount of additional charge offered. So, Lordship, here they have mistaken. Offered means which I have offered. So, here the statute is very clear, Lordship, and the legislative intention is very clear by putting 2 words. Here, Lordship, they are saying offered means this offer by the competent authority, which amount is fixed by the in 15.
Yes.
Then, Lordship.
You are saying offered means the amount they have.
Yes, grateful, Lordship.
Then should the word not have been fixed?
Lordship.
Should it not have been minimum?
I'll come to that, Lordship. I'll come to that.
Minimum fixed.
Yeah, I'll come to that, Lordship. That is just there, Lordship, in statute. Then, Lordship, kindly come to 27.5. The entire confusion is here, Lordship. I will clarify this position, then entire case, Lordship, can be. Lordship, come to 5. Then 5 is my part, Lordship. Subject to the provisions, these rules, the query lease shall be granted in favor of the applicant who has quoted the highest rate of the additional charge. So let's mean there is a difference. This legislature, they have used two words. In first sense, they are saying offered, and in my part, they are saying quoted. So I have, then the competence comes to play, Lordship. I have quoted the maximum price. Then Lordship, then comes Lordship. Another, then I'll come to the application. Rule 7, Lordship, for my case, I'm Rule 7. Within 15 days of such intimation, Lordship, within 15 days of such intimation, the selected bidder shall be required to convey his acceptance of the terms and conditions and to deposit the amount which shall be calculated in such a way that it shall be equivalent to 1/4 of total royalty and additional charge. Lordship, here also, and the amount contribution payable to the district mineral such and such. So, Lordship, after being qualified, there is a rider, Lordship. There, I have to give my acceptance. If I will not accept, then my bid will go. They will resort to Lordship 8 and 9. Let's say come to 8. The high selected bidder shall deposit the entire amount. Then 9 Lordship come. In the event of default of the second selected bidder, the competent authority may issue intimates of specified Rule 6 to next highest bidder, who then the required to be conveyed the acceptance and to make security deposit calculated in the manner mentioned in the sub-rule 7. Then Lordship, to clarify Lordship to my contention, Lordship, to convince Lordship, let's come to the Form F, Lordship, the application. That is also available, Lordship. Form M, Lordship, sorry, Form M. In my page 92, the prescribed form is there, Lordship, in which I will apply for the action procedure, Lordship.
Yes.
92, Lordship. Please, Data Lordship, kindly come to clause 3, Roman 3, Lordship. The requirements, solvency certificate and list of immutable property from the revenue authority. So this certificate is fixed, Lordship. It says enter my or property.
Where are you reading from?
I'm reading, Lordship, Form M. Form M is available in my book, page 9.
Oh, in the book. Okay.
Book, Lordship. If you read the same book, then page
Alright.
92.
Find it.
I'm the Chief person holding the same book, mine.
No, found it.
Let's see, page 92. I'm reading 3, clause 3. Page 93, clause 3, let's see, I'm reading. The requirement, these required particulars are given below. Solvency certificate and list of immutable property from the revenue authority. The certificate is one, Lordship.
Please come to Form M.
Lordship, 4, Lordship.
Form M
For
is Form M.
application for grant of co-religion.
This is the application.
Lordship.
Now read 1.
Lordship.
We submit
An application for
an application
an application. Lordship, grateful, Lordship.
for
Lease.
a query lease.
Lordship, grateful, Lordship.
All right.
Lordship.
For
For Lordship.
mineral
Lordship.
for the term of so and so.
Lordship.
Hectares of land
Lordship.
in the area specified
Lordship.
in the annexure given below.
Lordship.
So this Form M
Lordship.
is for one query
Grateful,
area lease.
Grateful, Lordship. Grateful,
Alright.
Lordship. Individual separate application, Lordship.
Yes.
Lordship. So my humble submission. Here, Lordship, I have applied separate applications for all 2 queries because there are 3
separate applications for all 2 queries.
Lordship.
But the solvency certificate,
Lordship.
according to you,
Lordship.
this has to be calculated
Lordship.
on the basis of that.
Lordship.
If suppose
Lordship.
you have to give solvency certificate to the tune of 50 lakh,
Lordship.
you give 1 crore.
Lordship.
May give 1 crore.
Lordship.
For the second, you may give 1. Instead of 20 lakh, you give 1 crore.
Lordship.
So you have given 2 crores.
Lordship.
But whether you can give 1 crore in respect of one query area only, one application.
No, that is not my case is, Lordship. This 40 lakhs qualifies both the.
This is what I am observing.
That is what you are being
That
asked.
suppose you were required to pay 30 lakh
Lordship.
for one. All right. You paid 1 crore. You gave a solvency certificate of 1 crore.
Lordship.
All right.
Lordship.
In the second, you were required to pay to give solvency certificate of 20 lakh.
Lordship.
You gave 1 crore.
Lordship.
All right.
Lordship.
Now you can you take this plea that because in one of them, I had given 1 crore, therefore I qualify for both of them?
Lordship, solvent certificate is one, Lordship. It cannot be two, Lordship. Solvent certificate, Lordship, I have brought the rules, Lordship. It is come up.
Solvency certificate, Mr. Solvency certificate cannot be one.
One, Lordship.
Solvency certificate cannot be one if you are participating in many, because we will have to give solvency certificate for individual queries.
That's
It
true,
is not that one solvency. If you have to give a solvency certificate, then for one this thing you will have to give this. Who knows and therefore we wanted to know whether both the procedures are combined or separate.
Separate.
If they are separate, then you will have to do it separately.
Solvent certificate issued with certain rules. It is, Lordship, one can be granted to each individual, Lordship.
All right, all.
Lordship, another aspect, Lordship, kindly see, here, Lordship, also they have given, Lordship, kindly see same clause 4B, there also indication. There is no bar to participant has already applied for co-release but not granted. That is also there, Lordship. Then, Lordship, kindly come to clause 5, next page, Lordship. NB, that is very important, Lordship. It gives the indication so the rules is concerned. The application shall be summarily rejected if the rate of additional charge quoted is less than the rate additional charge specified in the notification. So
So that is if the additional charge quoted by you is less than the minimum quoted in the notice.
Quoted. So no, I'm giving emphasis to the word quoted, Lordship. So that's why, Lordship, the 27.2, 27.4, Lordship gives offer and 27.5 gives word quoted. Lordship, very
So
interesting.
you are saying they have offered and you have quoted.
Yes, Lordship. And that is the calculation. That is the calculation. And Lordship, kindly see, very interestingly, I'm sorry to say, Lordship, this aspect has already been decided by this honorable court and in the present petitioner's case, Lordship. How he has not mentioned in writ application, I can answer this suppression of facts. Lordship, kindly another writ application there before, Lordship. Case 36 is there.
Is 36.
36, there is a noting, Lordship, writ petition, Lordship, writ application number, Lordship. 96, Lordship. Writ petition 96 is there. This is connected to this, Lordship, kindly see the noting. Because it was brought to before Honorable Condemnation Bench, Lordship.
96 of 2021.
21. The very same petition was there. And he was unsuccessful on the very same ground. And his writ application was allowed. And he participated for the same ground. But you kindly come to page 96. For if the writ application applicable.
96 of that writ application.
That writ application. This very much Navin Misra was there.
Yes.
Lordship, is the contents of the writ application. The very first language says because he has not given the solvent certificate as per the calculation of the authority, they disqualified him and the appellate authority gave judgment against him. And he challenged that order before Honorable this court. And Lordship, kindly see this court's order, that is order dated 23/2023.
Yes.
He's been allowed to participate in the bid and he subsequently became disqualified. Lordship, kindly see page 23/2023. The very same petition of inquiry, Mr. Lordship. I'm just reading second para 3, Lordship. In compliance to the order of this Honorable Court dated 24/2023, since both the petitioner and opposition 5 agreed to bid for 221, this court find order dated 15/23 called upon the petitioner and opposition 5 to quote their bid and produce the same before this court in a sealed cover so that better price can be achieved by the state. Accordingly, Lord and Counsel appearing for the petitioner and opponent 5 produced the sealed cover before this court. The opening of the same in the court itself was found that the petitioner has quoted 236, where the opponent has quoted 302 towards additional charge for Chandi Post handbed. Such memos be kept on record in view of the such, since the opponent 5 has quoted highest price, then the petitioner let the Sairat question Chandi Post settled in favor of opponent 5, who shall quoted such. So, Lord, this very same prayer has been allowed by Honorable Court, and he has participated, being disqualified in the bid, and subsequently being lordship in lost in appeal lordship. This court also allowed him to participate. He matched the price and allowed. The very same question is now under challenge by the same petition lordship, and it has never been brought to the lordship's notice in any manner, lordship. Then lordship kindly come to my regender. I have given the figures because how they have miscalculated. Lordship kindly see my regender. Lordship, before coming to that, Lordship, another thing I can bring to Lordship's please come to Lordship, page 167. Page 167 for a moment, Lordship.
Yes.
167, in fact, Lordship, from the day one, there is no interim order. Nothing, Lordship, is only it is under adjudication. And I have, Lordship, completed, I have executed lease since 1/6/22. I was operating, Lordship, and Lordship kindly see page 167 for a moment. By the communication, Lordship, I don't know under what authorities communication made, and they have stopped mining, Lordship. There is no interim order, nothing set of page 167. Regarding the direction of stop mining operation of, this is letter to me, Lordship. Reference letter of additional government advocate of Office of the Advocate General Orissa Katta.
Just a minute.
Lord, sorry. Lord,
I may go back for a clarification.
Lord, sorry, Lord.
So what is the distinction between
Lordship.
These two expressions
Lordship.
which you wanted to
Lord.
draw? Offered and quoted.
Quoted. Lordship. Again, Lordship, permit, then again I can, Lordship, explain.
Yes, please.
Lordship. Lordship, my humble statement before Lordship. I have gone through the Black's Dictionary, Oxford Dictionary, but Black's Dictionary and...
No.
Lordship,
see, there is difference between the words.
Lordship,
literal meaning, you may be right.
Grateful, Lordship.
But for the purpose of
this, Lordship, 27(2), Lordship, again I am reading 27(2) is the Lordship mandatory provision under the rules, Lordship.
Yes.
The notice inviting applications for grant of co-release shall be issued by the competent authority and shall specify the minimum guaranteed quantity of the minor mineral to be extracted in a year by the applicant and the minimum amount additional charge payable for the same age determined under Rule 15.
According to you, this is offer.
This is called offer, Lordship. Because, Lordship.
Difficult.
Lordship.
Difficult.
Then, Mr. Dole, why are the words minimum charge not mentioned there?
Minimum charge is there, Lordship?
No, in 4.
4, Lordship, because they have specified.
See, now you have to read, you may have to read this 4 and 4 and 5 together. Roman 4 and 5.
That I'm reading, Lordship. Because, Lordship, kindly.
So offer becomes quoted.
Yes, Lordship. Here is offer, Lordship. First time the legislature, Lordship.
All right.
Legislature, sorry to put Lordship if I'm, but this is my understanding. I am to convince your Lordship because Lordship, because that's why Lordship 4 Roman 4 speaks up. First time they have used the word offer. So Lordship, again I'm reading the language, Lordship.
We have read the language 10 times.
Lordship.
We have read the language 10 times. We are ready to hear you 20 times.
Lordship.
But only because
Lordship.
2 words have been used at 2 different places.
Lordship.
Therefore, they should be read differently is not compulsory.
I'm not on that. Lordship, I am confirming. I'm Lordship, because I am giving emphasis on this argument because of this writ application. Because the petitioner had approached this Honorable Court challenging the same contention, Lordship, because his bid was rejected on the ground of.
But has that been decided?
Yes. He's been allowed, Lordship. He's been allowed.
Has that point been
Counsel,
decided?
just because he did that Therefore, we are not going to follow that.
No,
All right.
I am not on that, Lordship.
If something specific has been decided on this point, on that point, we have either to consider, to defer, or follow. All right.
Lordship.
So, is there any decision on this point that these two words are different, not to be read together? They are entirely different. Offer and this quoted.
Then Lordship,
What you offer? See,
Lordship.
I offer that I'll give you this pencil for 5 rupees.
Lordship.
All right.
Lordship.
This is the price which I quote.
That is offer, Lordship. My humble submission.
Yes.
That is offer by the employer. So this is my offer.
This is
If you want to accept. Then if not, then you quote your price.
Sorry. This I offered this pen and quoted the price.
No.
What is this?
But Lordship, I have.
All right.
Lordship.
Now, because there was some clarification required, I got that.
Lordship.
All right.
So, Lordship, then Lordship, my second contention, Lordship, can you see if you are not convincing Lordship on this point? But this is my humble submission, Lordship. That's why, Lordship, this figure has come up, Lordship. They have come up with 67 lakhs. And I am saying, Lordship, this 40 lakhs is also qualifying both the bids, Lordship. And I have given the, Lordship, then I, Lordship, kindly come to annexer, my regender, Lordship, page 190, Lordship. No, not 190. Lordship,
Starts at
page 9, Lordship. 187, paragraph 9. 187 of my regender, 9. Because this is practice all over state, not the first case, Lordship. That's my submission.
We don't go by practice, we go by law.
Lordship, this is because they have come up with the state has come up with the law, Lordship.
Yes, please.
Lordship, Lordship, that at the cost of the repetition, 1/6 state clarify that to rule 27(4) Roman 4 never gives any mandatory provision.
where I'm not getting.
Lordship, page 187. 187.
For the
Brief, Lordship,
Sure.
brief my regender, Lordship.
187, you can see an share 5 के ऊपर चले जाओ 5
187 counter affidavit.
no
No, my regender, Lordship.
counter affidavit. You're right, counter affidavit. You are reading counter affidavit, Mr.
Sorry, extremely sorry, Lordship, counter.
Oh,
Yes,
so that will be covered by
Counter.
187. Yes.
Yes.
I'm your opposite party, Lordship. That's the whole difficult to me. Lordship.
Yes.
Lordship, that at the cost of repetition, it is 1 second clarifies that Rule 27(4) Roman 4 never gives any mandatory provision to submit solvency on the offer price by the applicants. Rather, it has given emphasis on the offered amount of additional charge fixed by the authority. The language employed, Rule 27 Roman 4, it is very much clear regarding offered amount, which is always the offered price of the auction inviting authority, and it is never the participants. To demonstrate the contents of the submission, the present deponents files here is series of advertisements adopted all over the state and annexed to the annexer A by 5 series. Lordship, kindly come to, it is all are in vernacular, so Lordship, kindly come to page 199 for a moment. My Honorable Justice Rath can read, Lordship. Lordship, they have given the entire figure, exact what I am submitting, Lordship, that is reflecting in the advertisements. Lordship, page 199, Lordship, kindly see.
You've given some which are also in English. So read 1 or 2 of that.
But the relevant person is at 199, Lordship. Come
Okay.
199.
Okay.
Lordship, I am reading. Serial number 6, Lordship, bottom of the page. Carrying solvent certificate, Sampruta Khoniro, Barsiko, Utron Hebagotiva, Mode minimum guarantee guarantee, royalties, Saman Orthoro, valid solvency Pramapa Dakalo. So, Lordship, as per the offered price by the employer, that has to be matched with that price.
Abedana carrying kara.
Lordship.
Solvency certificate.
Solvent certificate. Minimum royalty, MJQ, royalty Parivanna Saman Orthoro. So, Lordship, as reflected in the advertisement, they have to match with the offered price. Offered means, Lordship, that is the price offered by the competent authority. Then, Lordship, kindly come to page 205. 205, another, this is the competent authority of Lordship Bonai.
Please keep in mind that in 2021, it has been amended.
Lordship.
So whether this is in consonance with that, you just
Lordship. Then, come to page 204, 205 lordship. It is of Kalahandi. 205 lordship kindly see serial number 6. Let's got it. 205, 6 serial number 6. Abedanakari Lakhe 70,000 lordship. They have given the price also. 18 months other validity have a salangna ate. Let's kindly come to page 207. That amount also is reflected at 207. Let's kindly see. That amount also they are at 207. Let's see. But then let's kindly come to page 213. Annex 213. Let's see.
Yes.
213 also lordship, same lordship. आवेदन का solvent certificate minimum करना quantity एम royalty परिमाण ना समान अर्थ. Then lordship kindly come to another
You will have to
page.
give English translation.
English translation copy, yeah, lordship, because
Do it.
I'll give English translation copy.
Any ODI thing you rely on, that you have to give.
Lordship, only that part. That
Lordship Kori, can I submit one thing, my your Lordship Kori? My lord, what is happening, my lord? In fact, before going to any notification for auction, the Tahsildar is the competent authority and the collector is the controlling authority. Before any notification, he has to get approval from the collector, being the controlling authority. Your Lordship can see for a moment 2715. 2715 is the language. The minimum amount of additional charge to be quoted shall be such as the competent authority, the Tahsildar, in consultation with the controlling authority, collector, decide and specify in notice.
Again, that word quoted?
Lordship, I'm coming, my lord, I'm coming.
No.
In notice, inviting application for grant of co-release, provided that minimum amount of additional charge so fixed should not be less than 5% of the rate of royalty. Lordship, kindly see page 36 for a moment. That's the notification. 36 for a moment.
Yes.
36 Lordship, kindly the column minimum additional charge per cubic meter. First Soirat rupees 9. Second Soirat Sabora is 15. Third is 10, my lord. So when he quoted his rate, my lord, this should not be minimum that. That's why the form M, Lordship, can see. This should not be minimum this fixed by the in the notification itself.
That is the meaning of minimum only.
Lordship, this,
not be less than
my lord, then the 27 4 will taken into picture, my lord, because the taking into consideration the offer, the successful bidder or highest bidder will be decided. Otherwise, all the bidders' rate will be same. And Lordship, that's why
Rate will not be the same. They might submit the same solvency certificate.
no,
but rate
not
will not be the same.
rate will be same, my lord.
How can the rate be same?
Because his submission is that the minimum additional charge, quantity, and these fixed.
He's saying that is for the solvency.
Solvency, my lord. Solvency, my lord, because solvency will take into consideration of the offer. And that's why in the form M, I'm reading that form M once again, my lord.
No, confusion is because of the wording used by you. You could have made it more clear.
The solvency certificate is relatable to the offer or
My lord.
the amount quoted in the notice or the amount offered by the bidder. The solvency must be relatable to the amount.
Solvency will be solvency, my lord. The solvency will be fixed. Otherwise, if you take into consideration NB.
Whatever submission you make,
Lordship.
but the reasoning will obviously be that whatever offer you have
My lord.
your solvency.
No, Lordship, my humble. My humble.
Otherwise, the solvency will be same.
Lordship, I demonstrate all advantages of the state. It speaks of Lordship as for my submission. So my humble submission, Lordship, can in this case, two appellate authority gave judgment in my favor, the sub-collector. And this appellate we are relying, Lordship, that is also sub-collector. So Lordship will be higher officer, Lordship, secretary will put, all time this issue will be Lordship result. Lordship, the higher officer will give this affidavit to clarify it. So everybody.
Not necessary.
No affidavit is required. We will go by law.
Lordship, I can convince Lordship.
Yes.
I can convince Lordship.
Give the
Translation copy shall give Lordship and Lordship.
English translation of such documents which are in Odia language
he filed by learned counsel for
Relevant person, lordship.
Relevant portion.
Relevant person.
relevant
Relied
portion.
on
Relevant, lordship. Otherwise,
Relevant portion relied on by you.
relevant, lordship, lordship.
Relevant person be filed by way of supplement additional affidavit
Yes.
by Monday.
But by lordship.
This case on Tuesday.
Wednesday, lordship. Wednesday.
Only 1 minute. I will take.
1
The
minute.
lordship can see the definition of additional charge. It has been given in section 2. That is the definition of additional charge. A bidder is to offer. Additional charge means the amount payable by the successful bidder on unit quantity of minerals towards auction money in addition to other charges leviable under the disputes. So therefore, it cannot be conceived that whatever price has been fixed in the minimum additional price fixed in the notice, that is the amount to, on that basis the solvency will be calculated. The definition is the highest bidder will offer the additional charge.
Lordship, Wednesday, Wednesday.
Additional charge,
We will see.
no,
Wednesday, lordship, Tuesday, Wednesday.
Mr. Mahanti, you check. I think there are a number of decisions on this.
My lord,
Lordship, I have also
taking into
brought number of
consideration of
judgments,
offer, my
lordship.
lord.
I have also brought lordship.
Nowhere it is quoted. All the times were offered. Throughout the
No,
state.
because of your notice, I think there are a number of.
Number of lordship. Your lordship will
The type
decide
of
the first
notice
case
you
for us in
publish.
Odisha, lordship. This will the first case.
हाँ के मना करूँ who denies
reading whole of the provisions, this type of, by applying any rule of interpretation, it cannot be possible that such a interpretation is to be given to the non-fixed in that rule.
No, but we must clarify.
Lordship.
Lordship will clarify.
Lordship, correct, clarify, lordship.
Lordship put up on another date.
Wednesday.
What?
Yes.
Grateful, lordship. That's why 2 p.m. lordship. Lordship.
Item number 28.
How many times time?
Take instruction. Instruction for what?
What is that?
Certificate matter.
Last occasion, I only.
Which certificate?
Where initially there was a mark called NC and we came to the court. The court directed him to reconsider and they removed it and issued me a fresh mark.
Yes. Why? What happened?
Only last occasion I take time. I only take 1 week here because we already sought for instruction from the New Delhi and they requested me for short adjournment.
No, because detailed affidavit is not necessary.
Only
Simple thing
that
as
one,
regards
only that.
date of issue.
That specifically I sought for that instruction, my lord. Your lordship may.
But be ready for some payment also.
My lord, I entered the appearance on 27/6, madam.
When this is matter on. When? 1 week. 1 week?
Lordships.
5th or 6th, your lordship.
5th or 6th of August, 5th or 6th of August.
That is 2 weeks. Okay, 6
Seven.
or 6, 8 or 6 or 7, whatever.
Yes.
Item number 29.
In this case, I am challenging the order dated 10/11/2023 by the annexed 12 page 48. I am challenging the order dated 10/11/2023 by annexed 12 page
Just a
48.
minute, just a minute.
In this matter, Lordship, in fact, Mr. Pandey is appearing for OP number 4. But
My lord, I will pardon, I am on VC. I asked my learned friend to take time on my behalf, my lord. I have appearing in this case, my lord, for opposite part number 4. I have also filed a caveat. When the matter was listed, my lord, caveat was not listed, and the lordship was pleased to issue notice upon the matter, my lords. I already appeared on 18/7/2024, my lord, but my power has not come. So my humble prayer, my lord, let it be come next week, but along with my power, I am ready to argue on any day.
Yes, I have no objection for adjourning the case because the notice was issued on 12/12/2023. This also got directed to the file counter. Without filing counter, now the government has issued a letter on 27/6/2004 that why you will not be disengaged from the service. I am continuing since 4/5/2011.
No, but the caveat is there.
I have no knowledge that W was admitted. Fixed date till then status quo because I am continuing since 2011.
With due respect, my lord, the ADM has nullified his appointment. Thereafter, they approved this honorable court, but honorable single judge also nullified his appointment, my lord. My humble submission, next week, any date, madam, ready to argue.
No, he is stating that since he is continuing in service and he has received a notice as why he should not be removed, if he adjourn the matter and he is removed, it will become infructuous.
My humble submission is, it's at the notice stage, my lord. What my Lord Senior is submitting, the notice has issued, why not to terminate it?
All right, let us see the order. Yes.
Maharaj, running page 60, the observation of the court. The court has, I have filed the identity card of the petitioner, residential certificate of the petitioner. 60, the running page 60, the order of the honorable single judge.
Challenge WS 2790.
I have challenged the order of the honorable single judge in annexure 12, page 48.
12 page
48.
You are referring to page 60.
60 is the running page of the observation of the learned single judge. Without considering the appellant's identity card, residential certificate,
What is finding?
finding that the ROR pertaining to Khata number 13 of Mouja Malaravada, based on which the Tahsildar Bhograi granted a residential in favor of the petition, the address column is given the petitioner, which has been recorded the name of the deceased father of the husband of the petitioner has been mentioned as a Negua.
You be president of Anarvadi Center.
Yes.
This aspect has been addressed by the appellate authority.
Yes.
You are not according to the appellate authority, you are not the president of that area.
Yes.
What is the opinion of the original authority?
The original authority is the CDPO. He is, after verifying the records and after verifying the residence as per issued by the Tahsildar, has selected me and I stood second. when the first person is ignored,
Forget first person, second person. The question is about your residential area.
Yes.
Where you have all within the Anganwadi center area. That is the question.
yes,
That question has been addressed by the appellate authority. That question has been addressed. That is a finding of fact that has been found to be correct by.
but that has not been taken into consideration the document issued by the same Tahsildar. That same Tahsildar. But that same Tahsildar, he has issued the certificate Tahsildar in 2016. I am residing in that area.
Already. We'll take it up next week. We'll take it up next week.
Till then,
Applies to us.
otherwise there will be termination.
Next week you can manage, mentioning this, you can manage, sir.
My notice has already gone. Has received notice.
Yes, have you received?
Mr.
Yes, my
Pandey,
lord. Yes, I have received. I have also appeared, my lord, on 18/6.
Four.
It is clear that any action taken against the applicant shall be subject to final outcome of the present appeal.
Deeply obliged.
Direct to the government to file counter. Whether they will file counter or
Counter.
writ appeal,
court directed the
court has directed.
yes on 12/12.
Disciplinary proceeding, my lords.
Well, 10. Where? The order has not been scanned. This matter we have heard last week. There is no order after 26, 2024. We had heard an adjournment. Would have an order?
12/12. State governor in TV. No, not required. Yes.
Last one.
Why you have not filed your affidavit?
I will file an affidavit.
Do it.
Well,
noting also. After 26, it has not been listed.
One request. Pursuant to order dated 27/6/2000 only mentioned. Okay, say on that order he is direct for disengagement. Only mention that order dated 27/6/2004.
There is some correction. There is some correction.
They're saying the.
No. Now during pending subject of supplement notice for disengagement.
You are saying pursuant to order of the single judge?
No.
Then
Sub collector. Directed for disengagement. 27.
what other action can be taken? Other than disengagement, no other action?
No.
Item number 30.
May I please? Then this writ appeal. In fact, Lordship, the order under annexure 2, order of the Honorable Single Judge is under challenge. Lordship, here the petitioner is a elected Sarpanch and he represents a particular Gram Panchayat. I compelled to approach this Honorable Court because of non-cooperation of the officials, Lordship, because he's come from a independent background, and a retired teacher, Lordship, the official did not cooperate, Lordship. That was the entire contention of the petitioner in the writ application.
So where is the order?
Order, Lordship, page 219, Lordship.
Yes.
Lordship, kindly come to page 220. My prayer has been quoted in the writ order, Lordship. The prayer was, Lordship, the opposite parties, more especially opposite party number 6 to 8, shall not be directed to allow the Gram Panchayat to function independently, strictly in consonance with the mandates of the Constitution. The opposite party number 6 to 8 shall not be directed to assist the Gram Panchayat in discharging their duties in terms of the statutory provisions and resolutions of the Gram Panchayats. And also the action of the opposite parties, more especially in opposition 6 to 8, shall not be declared as valid in law with appropriate direction and to act accordingly. So this was my contention and grievance before this honorable court, because the entire officials at the behest of the local political leaders, they are not cooperating with the Gram Panchayat, even if they are not all. I am the Gram Panchayat, I am the Sarpanch, Lordship, elected Sarpanch of the Gram Panchayat. Because, Lordship, since last 2 years, even if they did not allow to spend a single pie from the Gram Panchayat fund for the development of the Gram Panchayat. Because, Lordship, if I do a development work, the rule says, Lordship, Gram Panchayat Act says, the concerned junior will come for measurement and he will say, Lordship, whether I have completed the work or not. But due to non-cooperation, the officials, Lordship, I could not spend a single pie before the Gram Panchayat, Lordship. That's why I had approached before this honorable court, challenging, Lordship, only to give a direction to the opposite parties to assist the Gram Panchayat in consonance with law, so that development activities can be done, Lordship. And Lordship, kindly see, while dealing with my matter, Honorable Single Judge, though have allowed my writ application, but Lordship, taking some points, Lordship, have rejected my writ application. Lordship, kindly see what are the grounds, Lordship. Page para 4, Lordship. Though the prayer is non-specific about execution work, Lordship, reading. The paragraph 9 of the writ petition, it has been mentioned that 5 projects works have been completed by Gram Panchayat, and the dispute revolves around such 5 works, that the measurement of such works are not being taken by the junior engineer, resulting withholding of the bills of the same. It is relevant to reproduce the paragraph 9 to 10 with writ petition. Lordship, the entire, they have quoted the Lordship. Lordship, by virtue of different. No, Lordship. No. My Lordship, because I compelled to come this Lordship group, despite my entire effort. Lordship, I approached before collector, I approached before secretary, and Lordship can speculate the case. The state government approved the work, but the junior engineer did not execute. Lordship, kindly the contentions in all my resolutions and all these works have been approved by the state government, by the Panchayat secretary itself. But because, Lordship, the lacuna is there, Lordship, there is a technically instead of the. No, now at this stage, Lordship, direct the video to consumer repentance, it will suffice.
The PM of the video. We should direct the PM of the video to place the file before the video for the video to take a decision.
No, that is not my contention, Lordship. Lordship, kindly come to Lordship. Then Lordship, kindly.
And if your video is not listening to you, then why are you not?
No, I am not on that, Lordship. Kindly come to page 21. Why I compelled for writ appeal, that is also there, Lordship. In writ appeal, Lordship, kindly come to page 5. Para 5, Lordship.
5 of the writ appeal.
Writ order, Lordship. They have allowed my writ application, but Lordship, traveling beyond my Lordship contentions has come, Lordship, I compelled to approve this honorable court. It is needless, Lordship, it is needless to say, to observe here, with respect to the prayer of the petitioner, that everyone is bound to act in consonance with the law and to discharge that duty in terms of the statutory provisions, whether it is the.
We shall lay down the guideline in your case that in such matters the court should not interfere, should not entertain such data application.
Lordship, I am not clear. I am not clear to Lordship.
Yes, you are very clear.
No, Lordship.
Tomorrow, if an MLA comes to this court,
Lordship,
that this is the fund which has been allotted to me, and we are not being able to utilize the funds, because the minister is not listening to him. This is not our job.
No, I'm not on that lordship. I'm not on that lordship. I'm not on that lordship. Lordship,
This will be the end of the matter.
lordship. No, I am not on that lordship because the honorable single judge has allowed my petition.
Your petition ought to have been dismissed. We will dismiss your petition.
It has, Mr. Dolly, it has
She
been
done that
dismissed.
lordship, but my humble contention.
Not allowed then.
Lordship.
Yeah, writ petition has been dismissed.
No, what have they done, lordship?
Stating that the prior
Yes,
approval was
lordship.
not there.
That I will clarify, lordship. If that is not there, then I don't have any case, lordship. Lordship, kindly come to Rule 16, lordship, for Contempt Act. Lordship, Rule 16 of the Gram Panchayat for movement, lordship.
Rule 16 of the Gram Panchayat Act
Lordship.
can be read by the secretary of the department also, can be read by the concerned minister of the department.
Lordship, absolutely correct. Being held everywhere.
See, if you are Sarpanch and if you are not in a position to get anything done,
Lordship.
you should not hold that position. Your junior engineer is not listening.
That is not my lordship. That is whole difficult, lordship. That is not.
Suppose we are giving you another example.
Lordship.
If a police officer comes to the court,
Lordship.
that please see, I apprehend that there shall be theft in my house.
Lordship.
This thing, the inspector in charge, please issue direction that the BSP should ensure that there is no theft in my house. What is this?
That is speculative of the case, lordship. Lordship, junior engineer is not my staff, lordship.
Unless there is something.
Lordship, junior engineer.
I don't have time for this.
Lordship, kindly allow me to place my case at least, lordship. Lordship, kindly allow me to, because I am raising every pertinent question, lordship. Yeah, lordship, kindly see, in view of the Article 243G, Gram Panchayat has the independence. He has the independent capacity to deal with every matter, lordship. But here, what has done, lordship? A junior engineer appointed by the block government officer, he is coming on the way. That was my entire grievance, lordship, because the Gram Panchayat should work independently. That's why lordship have allowed my petition that Gram Panchayat can work independently. But that was not my contention that if I have exerted some work, that was mere some examples that due to non-cooperation, this junior engineer, the work has not been completed. But the honorable single judge hold in relying upon Rule 16 to 19, lordship, that the due to approval of the junior engineer for completion of the work is mandatory under law. So that is my contention, lordship. Kindly have a glance to Rule 16 for a moment, lordship. Lordship?
We did not.
Then lordship, I have nothing to say. If lordship will not hear, then I will address lordship. If lordship pass any order, I don't mind.
Item 31.
May I please your lordship? My lord, I am in virtual mode. Lord, today I only want to press my amendment petition, Lord. I have 4563 of 24. Lord, in my schedule of my amendment, I have given that the portion of my amendment, Lord. That, Lord, I want to modify a little the paragraph 3 and to introduce a new annexure, Lord, which has been passed by the Lathikata Tahsildar. And Lord, I want to modify my prayer to quash that same, Lord.
What is your writ petition about?
My writ petition is, Lord, this is a PIL, Lord, where illegally the Tahsildar Lathikata has converted my Gochar land used by the Adivasi people to Abad Jaga Anyavadi and then hand over to IDCO to make his own, Lord. And that is the main challenge, and that is all done behind my back. That order of the Tahsildar, I received it after filing my case, Lord, which I want to introduce it.
Just a minute. Just a minute. I'm saying what is this? What is your IA?
My IA is for amendment of my, sorry, Lord, this amendment of a writ petition, just to introduce that new annexure passed by the Lathikata Tahsildar, where they are ordered to give it to IDCO, Lord. That I want to challenge it and to want to pass it, Lord, in my prayer.
IA number 4563 of 2024. This application has been filed, taking amendment in the writ petition. What is the amendment?
Amendment is, my lord, that order passed by the Tahsildar converting my Gochar land into Awadh Jaga Anavadi and handing it over to IDCO. That is, I want to challenge it, my lord, because that is the Gochar land used by the Adivasi people, my lord. In behind the back of the Gram people, the village people, my lord, that has been that order in passed.
May I just intervene here, my lord?
Yes.
He challenged Annexure 6, which in vernacular, there is a proclamation by the Tahsildar giving notice to the general public to file their objections because the government wants to convert and hand over some Gochar land to the IDCO. So it's a notice of inviting objection. Yes, Annexure 6.
He had filed.
My lord,
that.
I am coming.
Mr. Rankar, 1 minute, please. Thereafter that order.
Okay.
So you want to challenge that order?
That I understand, lords. Now, you can file a fresh writ application, lords.
Okay. Yes, what were you saying?
My lord, my saying, my lord, that what my learned friend is making the objection, my lord, that Tahsildar, he has passed this order in the name of a different Gram Panchayat. They have given the schedule of my land, but we issued that order on a different Gram Panchayat, on a different village, my lord. That is, your lordship may see. And I am coming to the annexure.
What do you mean, your name?
My name is village Nuaga. That is Gram Panchayat Chiktamati. And they have issued, your lordship may see, that order. I am coming.
Which order? The order which you have introduced by way of amendment?
No, my lord. That order is there. Now I am only want to amendment that order passed by the Tahsildar in which he has directed converted the Gochar land into Awadh Jaga Anavadi, my lord, and handed it over to IDCO. Your lordship may see. That order I passed in my amendment petition, but your lordship, I have annexed in my amendment petition.
IA 4563 is annexed to that.
I think that annexure that is to be annexed, my lord. And here your lordship may come to annexure 6. If my learned friend is making objection, this is to be done in hearing.
Please let us. Where is that order? What is the date of the order?
My lord, that the date of the order is 6/5/22, my lord.
So 6/5/22, why
I have annexed it.
Amendment? 6/5/22 was passed long back.
And the writ application.
They are not giving it to me, my lord.
That he was not aware.
I received it after filing my writ petition, my lord.
So 6/5/22.
I received it after filing my writ petition.
He assailed in the writ petition a notice of 2021, and the writ petition was filed in 23. There he never brought to your lordship's notice that they filed an objection pursuant to the notice under Annexure 6. Now he has want to amend the writ application saying that 22 order has already been passed by the authorities for the alienation of the Gochar land to IDCO, my lords.
That order they were not giving it to me, my lord. I received it after filing my case, my lord. And your lordship may see.
No, we are allowing. So as to question the correctness of an order issued by the office of the collector and district magistrate Sundargarh, wide number 5653, dated 6/5/2022, whereby according to the petitioner, Gochar land being used by the tribals, by the members of scheduled tribe, has been handed over to. But what can we do? This is a 2022 order. They must have done something on that land.
They have not yet done, when I filed the case.
And this new annexure, will it be 4 series or annexure 11?
That will the new annexure will be.
Already have annexure 4.
Maybe set up.
One is, that may be that annexure 4 may be given as annexure 4A, and this may be counted as annexure 4, my lord. Because that
All right, let us understand what is the illegality in this.
yes, my lord. After converting the land, my lord, they've issued that patta which I had given in annexure 4, and I want, my lord, that it should be marked as annexure 4A, and this order is to be marked as annexure 4, my lord.
How is that order illegal?
This order is illegal because gocher land of used by the tribals, my lord, that has been behind their back. That were converted to Awad Jaga Nawadi.
Behind their back,
and handed over to
Notice.
Notice was issued, and you challenged the notice, and now you are challenging the order. So have you been set up by someone? This is PIL.
Because this order I received after filing the case, my lord.
No.
This order, unless I.
Therefore, we want to know what is the illegality in the order.
That illegality
in
the order is. Yes, my lord. Because the illegality order is that the order I received after receiving, after filing the case, my lord. This order.
We lack, Mr. Counsel. We do not find anything.
My lord, your lordship, see, I am conversing, my lord.
What is the illegality? Unnecessarily, you are making your submissions.
Okay, my lord. My illegality is this, my lord, that annexures, this present order passed by the Tahsildar Latikata, that has been done by, that is the order by converting the gocher land of the Adivasi people to Awad Jaga and Awadi.
How is that bad? Which it is prohibited by which law?
It is prohibited because that was used by the gocher land, my lord. And
Mr. Namtwar, if they had not de-reserved and settled it with IDCO, then you had a grievance. They have followed that de-reservation procedure and then done it.
That is behind the back, my lord, in clear violation of Schedule 5 of the writ petition, Schedule 5 of the Constitution of India, my lord. Because 32, at page 32.
Please wait.
Number of the Schedule 5 which has been converted, which has been de-reserved and handed over to the IDCO.
Yes, sir.
IDCO. Stop. In the facts and circumstances, this application is allowed. List this matter on 1 week to be taken up within first 5 cases.
Consolidated petition by. When will you file the consolidated petition?
By Friday, I will file it, Lord.
Yes.
Yes.
Item number 46.
Please, your lordship. The blacklisting order petition is challenged, my lord. Petition is a registered contractor, my lord. The 20th October 2023, government invited tender, which is a proposal, my lord.
No, where is the order?
That is Annexure 1, your lordship. It's a very cryptic order, your lordship. Page 18, sorry.
Yes.
Your lordship, I am permitted to place here the order.
Yes.
The 6 line, 7 line order, 3 line is the address and 4 line is the codal provision, my lord. Nothing is in pursuant to Department of pursuant to Department.
So whether
of
notice was given or not?
No, so blacklisting for so-called specific was not given. Clarification notice was issued. No blacklisting for the purpose of 3-year blacklisting. Appendix 34 was not issued. 2 notice was issued, your lordship. I am showing the 2 notice, your lordship. One is Annexure 7, your lordship. Page 75, 76.
Yes.
Your lordship, page 75, your lordship. Annexure 7, your lordship.
Yes.
Lord, this is to the address to the petitioner, my lord. Sir, you have participated in the tender for the above stated work, but during scrutiny of the documents submitted by you in connection with the tender, it was found that the following 2 number of works That is namely.
Yes, one notice. The other notice?
Your lordships. The clarification, my lord. The other notice, your lordship, annexure 9, page 78, your lordships. Your lordships. Page 78, your lordship. Your lordship, this letter, your lordships, kindly with reference to letter subject to cited above, it's that reply submitted by you in response to this.
So what is clause 34?
Your lordship. Lord, the clause 34 is your lordship regarding blacklisting. Lord.
That then this is notice.
No, 34, there is a 3-4 categories. Lord. Your lordship, clause 34 is page 33, your lordship.
Page 33.
Your lordship. Forfeiture of EMD, my lord, and
No, my lord, 34D, my lord.
I am just placing. Like, my lord. Your lordship. Here is a 2-3 grounds have been challenged, your lordships.
No, 30, just
yes. Yes, your lordship. 34 is, my lord, EMD will be forfeited in the following cases. D, your lordships. D, your lordship. If any of the statements, my lord, documents, certificate uploaded by the bidder through e-procurement portal is found to be false, fabricated, bogus, the bidder will be blacklisted and his EMD bid security forfeited. Your lordship, can you show cause? Show cause was, I have not uploaded 2 documents. Here is the order is passed. As per the clause 34, along with appendix 34 of PWD code, your lordships.
As per that, if you would have uploaded documents which are not forged or not.
Exactly. I have not. The show cause clarification was issued. You have not clarified 2 letters. I say that before, because they have invited tender. Your lordship know tender is a proposal. I am a bidder, my lord. I make a offer. Before expiry of the bid validity, they sought clarification all bidder. I withdraw my bid. I don't want to proceed this bid.
Because he has suppressed.
Let me complete. Thereafter, my lord, they sought a clarification that letter that your bid capacity, non-disclosing to bid capacity amounts to misleading. I immediately, my lord, within you clarify in 7 days, my lord. 7 days I clarified. This 2 letter, yes, I have issued my paper. I have not totally inadvertently. I have not uploaded inadvertently. It is miss of my office, and this will not constitute a misleading. Being apart from 2 works, I am qualifying the tender bid. Lord, thereafter, my bid was taken into technical bid in spite of my seizes my offer period, my lord. They considered my bid, say that I complied all criteria. That is annexure 8, my lord, page 133. And last it says, since the bid validity is not extended by the petitioner, you are disqualified. They proceeded in the tender. Thereafter, issue second letter of clarification issued that your answer is not clear. So
this is your submission that your technical, there should not have been evaluation of your technical bid. Your technical bid should not have been evaluated.
Exactly, Miller.
All right.
Yes,
because you had not uploaded.
No, I may be, my lord, I'm sorry. Here is a, my lord, technical bid should not be taken not uploading document, be bid validity period. There is a conditions, bid validity will be 90 days from the date of uploading. 31st January 2024, they sought all the bidders to evaluate the proceeding, that to extend the bid validity. I say, my lord, that next date, I don't want to extend my bid validity. Thereafter, my lord, after that, they sought clarification. This which I have now stated that 2 work I have not uploaded. Admittedly, I have not uploaded. And they say why this not amounts to misleading and take action under DTC. Clarify. I clarified. Yes, this work order issued. There is a misinterpretation. Missed my office. I could not upload it. This is not to.
File your affidavit.
Your lordships, thereafter, your lordships, they have appendix 34 of PWD code provides that there is a procedure of show cause notice specific by the chief engineer. Your lordship, Gorkha Secunda contention of the show cause notice, and here they have clarification. Your lordship, 2 notice. Your lordship, the specific. Apart from that, 2 other notices has not been issued. Your lordship. The 2 date chat.
So you mean to say, as per the notice, only reference was to that DTCN?
DTCN.
Nothing regarding the OPWD code where proper procedure.
Your lordship, the Gorkha security case, blacklisting, when the contention of the blacklist, very specific.
It should be exclusively mentioned in the
exactly, Lord. That's your lordship. But that is Gorkha security and they're followed by.
Sir, kindly see page 75, my lord, for a moment. We have stated that in view of the above, it is observed that you have misled the department by not reflecting these two works in the work in hand, thereby inflating the bid capacity. Hence, you are requested to clarify the reasons for such misleading information, failing which action as per the clauses bid of document and codal provision will be.
So the Supreme Court says
My lord,
that you are required to disclose your
My lord.
intention to blacklist.
Listing object.
my lord,
That is not there in clear terms. So that
Madam-
requirement you are not fulfilled.
my lord, at page 75, we have disclosed, my lord, as per the codal provision, you will be blacklisted.
No, blacklisting what?
Where is the word blacklisting?
It's my.
No, codal provisions will be initiated against you.
So
The reply,
provision-
So it can be anything.
Lordship,
So codal provisions can be anything, action can be anything.
codal provision, my lord, as per the OPW code, my lord.
OPW code, there may be so many things in OPW.
My lord.
He was not knowing that he is going to be blacklisted. So therefore, the Supreme Court says that you have to disclose in your notices that you intend to blacklist.
My lord.
So if that is not there.
My lord, Lordship, can I see page annex 9, my lord, for me. Hence, you are once again requested to clarify the reasons for such misleading and submit sufficient explanation so as to why action as deemed fit will not be initiated against you as per clause 34, section 1 of the.
As deemed fit.
This-
So
this
even
improves-
on the date of
Well.
issuance of this letter,
Well,
you were not sure as to what action you shall be taking.
And
my
this
lord,
has- this has-
only we have issued two
This
letters.
has improved his case with DTC and mentions that he has uploaded.
He has not uploaded, he has
Exactly,
suppressed.
exactly, he has not uploaded.
He has
Your
suppressed.
DTC and section 34 says if he has uploaded,
No, my lord, false statement.
just see.
Lordship.
Both the notices are not false.
34 D, my lord.
Yes.
If any of the statement, documents, certificate uploaded by the bidder through e-procurement is found to be false, fabricated, bogus, the bidder will be blacklisted and his EMD will be bid and security forfeited. He has suppressed, my lord.
So you're saying statement is bogus.
My lord.
It's not uploaded. The SOCOS was issued for clarification who has not uploaded two works. The clause, even OPWD code provides that I have annexed that code.
And he has himself admitted, my lord, at paragraph
He
9, my
might
lord.
have admitted that he is a thief, but you cannot, this thing,
Without a
you
trial,
have to
you
say, all right,
My lord.
that because you are a thief, therefore you'll have to be blacklisted.
My lord, he himself admitted, my lord, at paragraph 9, my lord.
What? The
He has
blacklisting.
taken a plea, my lord, and that while uploading the document, he has inadvertently missed uploading the work order for the two numbers of work.
Blacklist me.
No, my lord. They work in hand, my lord. Work in hand, my lord, he has to upload. Because taking into consideration his bid capacity will be evaluated.
Do it.
He has suppressed this.
We will give you opportunity.
My lord. My lord. My lord.
Where is the order of blacklisting?
Annexure 1, my lord.
The
Is 18.
petitioner in the present writ application has put to challenge an office order dated 16/3/2024 passed by the Office of the Engineer Chief Water Resources, Odisha, whereby the petitioner has been blacklisted and debarred for 3 years from participating in any bidding process with immediate effect according to codal provision under clause A, under clause capital A bracket F of appendix 34,
Mel.
comma,
34D, ma'am.
WD code, volume 2. Full stop. A short submission has been advanced on behalf of the petitioner to assail the impugned order. Full stop. He submits that it was obligatory on the part of the opposite parties to disclose their intention in a so-called notice about intention to blacklist the petitioner on any ground in accordance with the DTCN.
Tender notice, DTC.
DTCN.
Detailed tender call.
Detailed tender.
Tender call notice, my lord.
That is called detailed tender call notice.
My lord.
DTCN or OPWD code. So stop. Our attention has been drawn to the notices which were sent to the petitioner seeking its clarification. It's a company.
It's cooperative society.
Petition is a society.
Seeking its clarification.
Cooperative Society Limited. What is this?
Registered agency.
Seeking its clarification.
Company law.
It's about the misleading information furnished against a tender process. What is the description? What is the description of that tender process?
Tender, nature of work.
What was the tender?
The page, Annex 3, page 23.
Protection to
To
sport.
Protection to bank. Annex 3, page 23, Lordship.
Notice dated, what is the date?
Date of tender, my lord, is, my lord, I have given my date. Given the date, Lordship. That is 20th October 2023.
2010-2023. Bracketed Annex 3. What's wrong? A counter affidavit has been filed on behalf of the estate. We have heard learned counsel for learned AGA
My lord.
for the state. So on careful perusal of the documents brought on record with the writ petition and the averments made in the counter affidavit, we are satisfied that none of the so-called notices issued by the opposite parties, it was clearly stipulated that the opposite parties intend to blacklist the petitioner. First off, it having not been mentioned in the notices about the intention of the competent authority to blacklist the petitioner, comma, the impugned order, comma, in the court's opinion cannot be sustained in view of the Supreme Court's decisions. What are they?
Let's have given
Borukhan security and
this.
Not mentioned in the note.
Let I have make comparison regarding rationality. In first two graph, the so-called notice regarding Gorkha.
Gorkha says
Second in Bandita, Bobby Justice Nariman judgment is very clear that followed.
where is that?
Oh, that is serial number 2 of the judgment.
Gorkha which page and Vetinda which page?
Gorkha is paragraph 20, para 21, page 14.
Copy the compilation.
No, no.
Gorkha, your lordship, page number, your lordship, 1414.
This is 2014 volume 9 SCC 105 and Vandita Pharmaceutical 2021 volume 1 SCC 805. And such view of the matter, this writ application is allowed. Impugned orders and so is passed. First off, the competent authority shall, however, be at liberty to take press action after giving the petitioner an opportunity to show cause, comma, if the competent authority intends to blacklist the petitioner.
I am just your lordship sir given liberty in my request and I am only submitting it may the what take action blacklisting may that will be again the take appropriate action if accordance with law. That's only what your lordship what law.
It will, however, be open for the opposite parties to take appropriate action after giving the petitioner due opportunity appropriate action in accordance with law after giving the petitioner due opportunity of showing cause.
Yes, Lord.
Smile.
Pleasure.
Oblige.
Item number 32.
May it please. My lord, here the pertinent question to be decided by my lord, that whether the Tahsildar has the jurisdiction, my lord, to impose increased additional charge, my lord, on the petitioner on the basis of an instruction issued by the Revenue Disaster Management, that is 14/10/2019, on the petitioner, which is not applicable to the petitioner and without any so cause notice. My lord, here the factual background of the case is that here the petitioner is the leaseholder of a stone quarry, my lord, who was granted with the stone quarry. He executed one agreement, my lord. And as per the agreement, he was continuing to pay additional charge, dead rent, royalty, everything in advance, my lord, as per the agreement. That is for the period 2018 to 23, for 5 years. My lord, all on a sudden, on Annexure 4 on 26/11/2020, they issued a demand notice without any so cause that you have to pay additional, increased additional charge on the basis of a instruction that is 14/10/2019 issued by Revenue Disaster Management, which is annexed in their counter, my lord. Kindly have a glance. That is applicable to
Yes.
a government organization, and mine is
So
not.
kindly see the Annexure 1, my lord. This is applicable under Rule 40, my lord, because the order is passed by the Tahsildar. And this order is passed by the pursuant to your lordship order earlier, my lord. What Tahsildar did, my lord, Tahsildar granted lease 11 sources illegally without conducting the auction, my lord. Because in the Odisha minor mineral concession rules, my lord, the auction has to conduct, my lord. Lordship kindly for a sake a moment, my lord. Lordship kindly see page 44.
That was a mistake committed by Tahsildar.
My lord.
So, but they acted on the his representation.
Lordship kindly see page 44 for a moment, my lord. The royalty is fixed 13,27,872, whereas additional charge is fixed to 51,000.
So who complained that this is done illegally?
It came to knowledge of the government, my lord. Thereafter, the government directed the collector that you take the average sale price of the soil source and accordingly charge the additional charge. This is the.
But your action is against the doctrine of promissory estoppel.
My lord.
File your affidavit.
Lord, counter all.
I have filed
pleadings are
counter
complete,
affidavit.
my lord.
Counter affidavit.
Yes,
I have filed, my lord.
Yes, my lord.
Then nothing is there.
No, let him file appeal, my lord, because this is appealable matter. Tahsildar has passed the order. Pursuant to Annexure 1, lordship kindly see page 16, my lord. You have to file an appeal before the sub-collector.
Mistake is yours.
My lord.
This is purely a question of law, my lord.
No, one thing is mistake is yours. Sending to appeal, what will happen?
My lord. Because Tahsildar granted the lease, my lord, without conducting the auction. And in a very throwaway price, my lord.
So you have done this in all
11 sources, my lord.
11 sources you have
11 sources, my lord.
What happened to the other? They've challenged or they
Additional, no, they have paid.
They have
Yes,
paid.
my lord. Another I have also challenged, my lord.
11 sources, my lord. That's why.
It's
Two
listed with
sources
this.
Yes, my lord.
Is it listed with this?
No, my lord.
So 11, two sources were by Omega.
My lord.
No, not two sources, my lord. This is one source for Omega. Other petitioners
party.
are also there. This is purely a question of law, my lord, because they don't have the jurisdiction.
Petition number?
My lord, that right now I don't remember.
Give us.
Yes, my
Ma'am.
You also must be having, you can find out from the Tahsildar. If
Presently, I don't have.
We can take up the matter on next week.
Mile.
All right, both the cases.
Mile.
Give the number, we'll.
My lord.
And how many such instances are there in state? So many or
No, my lord, only two, I think, filed.
And what is the Tahsildar doing now?
Tahsildar, my lord, we have demanded the additional charge and they have paid, my lord. All the 9 leases are paid.
My lord, can I submit one submission? The calculation of that additional charge, that is also alien to this rule, my lord. My lord, they cannot take this 10 soirat and taking into the average of 5 highest additional charge. That is alien to rule, my lord.
So you are saying the calculation is also wrong?
Yes, my lord.
That means the Tahsildar had given the right amount.
No, my lord. It is happened. What happened in 14/10/2019, my lord? They give an instruction to all collectors and specifically for government organizations, my lord. And they cannot shift this to the private organization, my lord. My lord, it is specifically aborted.
where is that?
And my
My lord, there is,
plans to page 10.
Lordship, can you letter dated 24/9/2020?
Yes, my lord. That
Annexed
is
B/4, my lord.
page 10, my lord.
Annexed B/4, my lord.
Page 10. My lord, in the counter.
Page 12, my lord, it was specifically stated that 11 number minor mineral source, my lord.
My lord, found that page, my lord?
Counter annexes are not page mark.
Counter page number?
10, my lord. 10 annexure A/4.
A/4. Page mark means?
No, A/4, my lord, has
It
taken
is
out the A/4, my lord, in the annexed B/4, my lord.
Just a minute. It is a specific instruction for government organization, my lord. That is Rule 39(5).
He is absolutely correct.
Lordship, kindly see the page 12 for a moment, my lord. 12, my lord, annexed B/4.
No, but this is your policy.
My lord, this is policy. We have taken into consideration of this letter, my lord. Lordship, kindly see page 12, my lord.
Yes.
Page 12, letter dated 24/9/2022.
Yes. Yes.
In inviting a reference to the subject cited above, I am to say that on the report of the sub-collector Jharsuguda regarding settlement of 11 numbers of minor mineral sources beyond the scope of OMC Rules 2016, Collector Jharsuguda has been pleased to order for fixation of additional charges on the rate of royalty assessed during the time of settlement of this source under Lakhanpur Tahsil. The additional charge may be calculated as per the instruction issued by the government department by letter dated. Assessment of demand may be intimated to the lessee and collected forthwith. Name of the sources, my lord, 11 source, my lord.
Calculation has not that, not the principle. Basing on the letter of the sub-collector, it has been decided to fix additional charges on the rate of royalty assessed during the time of settlement of these sources. So calculation will be as per this. Any other method. Instead of calculation, then it will be from this. Not the principle of inquiry. Where is the letter of that sub-collector? Because on the report of the sub-collector, you have decided to impose. So what is that?
That I have not annexed. I will annex.
That is the important thing.
My lord,
Not annexed.
my lord, that I have not annexed.
No, your policy is this 4th of October 2019.
My lord.
From this, it appears that this additional charge is to be what is the
Reservation of
no
area for lease.
additional charge for lease of minor mineral sources in favor of government organizations.
My lord, government organization, because in the absence of auction, the lease will be granted in favor of the government organization. So the rate of the five highest additional charges will be taken into consideration as the additional charge. So what happened in this case, my lord?
According to you, this letter is only regarding fixation of additional charge,
Fixation of additional charge.
not the liability.
No, ma'am.
And the second is also, but where is the, yes?
Yes, my lord.
That is the question.
My
The doctrine of promissory estoppel will arise. This matter on, which is that other case?
My lord, that.
Can you give this matter tomorrow? Give us that case tomorrow.
My lord, can I pray on Monday, my lord?
If you give the number, we'll post it.
Oh, yes, my lord. Yes.
Monday.
Yeah, interim order is there. Interim order.
Item number 34.
Yes.
This is item number 34.
Mr. Mahanti, letter of the sub-collector you produce. Letter of the sub-collector.
But I mentioned not to delete that sub-item.
Sub-item B may
33.
be
Item?
33.
Item 33. 33, sub-item B may be detailed. 33. The second item may be
It has been jointly submitted on behalf of the parties at the bar that WPC number 28386 of 2023 be delinked as it does not involve the issue involved in the main matter, that is WPC number 37123 of 2023. Stop. Let WPC number so and so be deleted and placed on. You are appearing.
Lordship, I am for the opposite party number 2.
And who is for the petitioner?
I am for the petitioner. No, I'm sorry. I'm for the opposite party. I filed it. Mr. Rathod.
One week.
Lakshmi is calling it on 31st.
After 1 week. It will, so some item will come on after 1 week.
You are appearing in the second sub-item?
Yes.
Your name does not appear?
I'm in the first. I'm in the first one. I'm opposite party in the first one. I filed a vacation of not been there. So today I am filing the hard copy of my reply as well as Vocational.
File in the register.
Item 34.
No, 33, first item. 33 has been adjourned.
Adjourned in the first one. To 31st, Your Lordship, please.
31st. On 31st.
This can also be listed
Separately. Sub-item B is fixed.
Next week.
1 week.
No, deleted means it will also be listed but separately.
There's an item number 34. Here, Lords, in compliance of Lordship's order, we have submitted a proposal for sanction of 33 lakhs to the finance department. Now the finance department is concerned to Lords, pay the amount minus the HRA because he is not in service, he was disengaged. So that will pay in the meantime. And so far as reinstatement is also concerned, we will take a decision. Also, grant me 2 weeks time. In the meantime, fully comply the order.
Also grant them 2 weeks time.
I have given the letter to my senior also.
Requested on behalf of the condemned by way of indulgence. The matter is adjourned to 2 weeks for them to comply with the court's order. Violation of which has been erased.
Item
Contempt.
35.
Your Lordships, I'm appearing today for the first time, Your Lordship, for the contender. Your Lordships, but meanwhile, we've also filed a review. That was the bench, the then bench of the then Chief Justice and Justice outright. The review petition number is 66 of 2023. Both of them can be called together. If you don't make out a case in review, then
When did you file?
23.
2023 is up.
2023.
It is
2/3,
stated by-
2023.
It is stated by one senior counsel representing the contemners. Who is for the
I am there for the,
contemners that a review application has been filed seeking review of this court's order dated
7/3/22.
Seven, three.
7/3/22.
7/3/2022 passed in present contempt application. The petitioner has alleged violation of the said order dated 7th.
Review.
Okay, sorry, review.
66
number.
of 2020.
36 of
66.
Sorry.
And that's the item number 32 may be taken. Item number 42
Should be taken up to today,
tomorrow.
tomorrow.
Now I was think I don't have time.
No, if any matter is urgent, we can take up today. Tomorrow, all the matters will come.